day before? Yes, I do. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. I do. Good afternoon. Welcome to the House Judiciary Committee. We have several bills that we're going to be hearing this afternoon, starting with House Bill 202. Come on up. Delegate Nawrocki is here. If you want to bring your first panel up as well. Did I miss this State's Attorney Brave Boy here? All right, well, bring up your first panel and then we'll figure out who's going to go next in a moment. But Delegate, you get 3 minutes. Everybody else gets 2, just for people who are shaking the rust off a little bit, and go right ahead. Oh, it's a mystery these days. I don't want to get You're on. Go.
Okay. Thank you, Mr. Chair, Madam Vice Chair, colleagues. It's great to see you. For the record, I am Delegate Ryan Nawrocki, here requesting a favorable report on HB 202, criminal law, fraud, conveyance, lease, or possession of a residential property. This legislation is a common sense solution to protecting property owners, hold criminals accountable, and restore the faith in the rule of law. Unfortunately, squatting has become a growing epidemic, in many cases fueled by criminal networks that prey on innocent people with fake leases and counterfeit documents. My office was approached multiple times over the past year with instances of property owners who were unable to evict squatters in a timely manner due to the current restrictions within the law. This issue isn't theoretical, it's personal. It affects everyday Marylanders in ways that are heartbreaking and infuriating. A family in my community recently shared their story with me. They put their home up for sale after moving out of state, believing they had found a buyer, only to have the deal fall through because a squatter had overtaken the property. Now, living out of state, the family didn't even realize that this had happened, and unfortunately it was too late. The financial loss was devastating, jeopardizing their plans and their future. Another neighbor reached out to my office after noticing squatters had moved in next door. Almost overnight, the neighborhood changed. There were safety concerns, noise disturbances, and even fire hazards. She no longer felt safe in her own home. And then there's the case of a local property owner whose tenant passed away, only to have the tenant's son, a man who she didn't even know was living in the property, refuse to leave. By the time she could finally evict the gentleman, the damage to her property was a staggering $40,000. Since announcing my bill, I have had Marylanders all around the state write in support of HB 202. Another property owner said he had a squatter breeding and fighting pit bulls on his property and incurred significant damages. Another Marylander told us a story about a senior citizen who had to stay in the hospital for a month. Upon return to her apartment, the locks were changed and the police weren't able to eject the squatter because the law said they could not. So this bill, in summary, cracks down on fraudsters, those who create fake leases and counterfeit documents, who will face increased penalties. These individuals are the ringleaders and they must be stopped. It also deters criminal behavior with clear penalties, including fines and potential jail time. This legislation will serve as a deterrent to anyone that's contemplating unlawful occupancy of another person's home. But this isn't just about punishment, it's also about fairness. This bill also recognizes the plight of those tricked into this situation and ensures they're treated with compassion while relocated lawfully. Thank you, Mr. Chair.
That's very well done. All right, who would like to go next? And by the way, I mentioned the State's Attorney for Prince George's County. She is not testifying on this bill. She's testifying on another bill. I got my sheets wrong, and that's the first time this year, so better to be the first bill. Who'd like to go next?
I will, Mr. Chair.
Okay.
Good afternoon, Chairman Clippinger, Vice Chair Bartlett, and members of the committee. My name is Ashley Clark, and I'm here on behalf of the Maryland Multi-Housing Association, better known as MMHA. MMHA is a professional trade association whose members house more than 538,000 residents in the state of Maryland. We believe that HB 202 addresses a growing concern in Maryland's housing industry, the right of a landlord to not only know who resides in their apartment homes, but also to remove those with whom there's no contractual relationship. I will address one critical issue, and my colleague Hugo Cantu from AOBA will address the other on how this legislation impacts our respective members. Screening applicants is a critical component of the leasing process. While it is true and expressed to applicants and tenants alike that owners cannot guarantee safety, measures are taken to screen those who desire tenancy at their property. For many of our members, background checks may require a screening of the National Sex Offender Registry. In many cases, if an individual is listed on that registry, a lease would not be offered. Not being able to screen an individual who is living in their apartment home presents a safety concern and exposure to potential lawsuits. Simply stated, owners need to know who's residing at their properties. HB 202 seeks to provide an additional tool to help owners remove an unauthorized occupant, restore possession to the rightful owner, and mitigate a safety risk to their tenants and communities. It creates a path, in addition to a wrongful detainer action, when you don't know who the person is, making it criminal to fraudulently convey or lease property that doesn't belong to you. We believe that HB 202 will effectively combat those fraudulent activities by holding unauthorized occupants accountable, and we hope, as Delegate Naraki has stated, serve as a deterrent. It is for these reasons that MMHA respectfully requests a favorable report. Thank you.
Good afternoon, Chairman and Madam Vice Chair and members of the committee. My name is Hugo Cantu, here on behalf of the Apartments and Office Building Association of Metropolitan Washington, also known as AOBA. We're the leading nonprofit trade association representing the owners and managers of more than 23 million square feet of commercial office space and 133,000 apartment rental units in Montgomery and Prince George's County. We believe that HB 202 solves an issue that often slips through the cracks of real property rights. The right of a property owner to remove those who do not have a contractual right to stay in the owner's property. An essential part of our members' leases is that the tenant is not allowed to sublet their apartment. Executing a sublease that is explicitly prohibited is a material breach of the lease. Moreover, while the typical response to a breach of a lease is to issue a management notice that would be against the actual leaseholder, but not the unauthorized subleasee. An unauthorized subleasee may not vacate the property, which will require the owner to file a wrongful detainer action, and this legislation will enable the owner to not only regain possession of the property that is fraudulently acquired by the unauthorized subleasee, but also hold the tenant directly responsible for the fraudulent lease. HB 202 seeks to provide an additional tool to help owners remove an unauthorized occupant and mitigate any safety risks to their tenants and communities, as my colleague representing MMHA mentions. It is for these reasons AOBA respectfully request a favorable report.
Thank you, Mr. Chair, members of the committee. Lisa May, representing Maryland Realtors. This is a growing issue, not just here in Maryland, but across the country, and it really gets down to the underlying fundamentals of our housing market right now. Housing is scarce and it is expensive, and that makes people desperate. And it also presents an opportunity for people to take advantage. And that is what we are seeing right now, not just in rental properties. If you go online, you can find instances where people left for vacation, came to find their belongings cleared out of the house and someone else living there. So we really do need a comprehensive solution. The status quo is not working for property owners here in Maryland. One caveat with this bill is because you will hear others both today and throughout the rest of the session. This bill also gets to another type of real estate fraud that we are experiencing here, and that is seller impersonation. We've heard a lot about that in our more rural areas where people will pose as owners of vacant land in order to sell them, in order to steal deposits from legitimate buyers. And we think that this bill has the opportunity to deal with both that and the issue of squatting. We really do need a better solution for this, and we need to do better by our property owners here in Maryland. And for that reason, we ask for a favorable report.
We'll take questions now. Delegate Erican, please.
Thank you, Mr. Chair. Thank you guys for being here. I know that New York, has recently done something like this. Can you tell us a little bit about their law and if it's already in effect, how effective it's been?
Sure. So New York has enacted a very similar piece of legislation. So many states have a similar law that they've enacted. New York was one of the more recent ones. The impetus for that law, actually, according to Governor Hochul, the governor of New York, was a situation in Brooklyn. There was a house that was squatted in across the street from an elementary school. It turned into kind of a heavy activity of violent offenders, gang activity, that sort of thing. And the justification was we got to do something in that case, and that was the impetus to spur it on. It's been effective in New York. It's been effective in some other states as well. It's a bipartisan issue. This is not a Democrat or Republican thing. This is a thing that's impacting people all across the country, all across the state and all across the country, whether they're Democrats, Republicans, whatever, in every area of the country.
Delegates Embry, Simmons, Phillips. Embry, please.
Thank you. Thanks for bringing this bill. I mean, it's a really important. You hear me? Okay. But in my experience, when police are called to cases where there's two people and they have documents and they're both claiming ownership, the police are like, this is just not we don't have the wherewithal all the time, the resources to dig into this. And so it just feels like it belongs in civil court, the more complex. I understand your point, like if there's just squatters in the building and they absolutely have no claim to being there, but often there are competing claims. And I just wonder if you could comment on that, sort of the challenges of involving law enforcement in something that really isn't their bailiwick.
Sure. Delegate, that's a great question and a very fair question. Certainly you're right. I mean, it does have the ability to involve law enforcement in the process. It says, though, they may, not shall, right? So the sheriff or whoever is handling that in a certain jurisdiction does not have to evict someone from the property. So the normal course of action through the legal process can and still does exist here. I would also comment, though, that we involve law enforcement all the time to make decisions, not just with respect to housing issues, but many different types of issues, and they kind of have to sort out facts and information sort of, at the scene of something. So certainly it is a change from the way that we've been doing things here in the state of Maryland, but I would say that something is broken right now in the way that we are doing things here with this kind of epidemic growing in the state of Maryland.
Simmons, then Phillips, then Graham.
Thank you, Mr. Chair. When you look at the numbers, what does the numbers look like with the amount of people that are squatting here in the state of Maryland? What does that look at? And do you have a estimated price range of what is it costing?
Sure. I don't have direct numbers because this is one of the problems is it's hard to get to some of these squatters issues sometimes to actually know for sure who is squatting or who is not squatting. Certainly something we could try to get for you. I don't know if any of my panel has exact numbers on what that looks like. Do you have any thoughts on that one?
I do not, and the sheriff's office may know exactly how much they are dealing with it, but it probably is even going to be underreported because in some instances, people may offer money or some other incentive to get the individual to leave before law enforcement is called in those instances.
Sure. Mr. Chair, may I have a follow-up? Yes. So if we don't know kind of how big it is, how do we know it's an issue? How do we determine that it rises to the point of legislation?
Sure, that's certainly a fair question. So I could tell you from experience in my district that I've had several people in my district reach out about this issue. And speaking to some of our colleagues here, I know that they have other circumstances going on in their districts actively. So that's why I think that there needs to be something addressed here with this issue.
Thank you.
Thank you. My colleagues have asked the two questions that I had, but I do have, I know, right? So thank you, Delegate Naraki, and thank you everyone for being here, because this is an issue, right? How big it is, I think, was one of the questions I had, so thank you, Delegate Simmons. But I need you to help me to operationalize how this would work so that I could think it through in my head. How would this work? And it seems to me it might work differently if I have a multi-housing scenario than a single-family home. But could somebody share that, how you envision this would actually be operationalized if we pass this legislation?
Yes, sir, Delegate. Two things. I think because it deals with two issues, right? So the first issue that it deals with is the fraudulent documents piece, which I think is somewhat unique. There are other bills that are introduced this session that are attempting to deal with this issue, but they haven't maybe looked as extensively at this fraudulent document piece. Look, we can all go on TikTok or whatever social media channel right now and actually find some of these kinds of things going on right now where people are creating fake documents. They're telling folks how to create fake documents. So it would really kind of go after those folks that are willfully and knowingly creating these documents. And that's important there because there are individuals that are have been scammed themselves that are inside of a property and they don't even know that they've done something wrong because they thought that they had a legitimate lease or a legitimate whatever going on inside of that property. So it wouldn't necessarily go after penalize those folks in that way because they didn't know that the document was bad. So that's the first part of it. The other part is it does allow potentially for an expedited timeline. I get back to that story that I talked about in my testimony, Delegate, about someone whose sale of that home fell through just because the normal sort of course of action did not allow them to get them out of the property faster. And so it would potentially allow for that expedited timeline if law enforcement chooses to do so. They're not obligated to do so, but if they choose to do so. In that process, the property owner, though, does have to sign a sworn affidavit saying that this person is squatting in the property. So there are some protections there because obviously if someone is signing a document like that, they're signing a sworn affidavit, a government document, there's penalties of perjury if they themselves were somehow not telling the whole story or not being truthful as well. So there is protections on that side of it as well.
So if I understand you, we're really putting an additional burden on the police to make a determination based on the information that they have before there's an adjudication. Is that what I'm...
Sure, there is potentially an additional burden on the police, but I would add that in many of these instances, in some of these communities, there's already an additional burden on the police because there's other things that often are occurring in these properties that require police response and police presence to be there. When you're talking about places where there might be violent offenders there, if you're talking about, look, I have delegates, I've got 6 children. I would want to know if someone was living next door to me that was a sex offender. In the way that we're operating right now, because we don't know who that individual is, you could have a sex offender living right next door to you there or right across from a school or whatever the case might be where they may already be prohibited from being at by law.
But because they've got this sublease, which they weren't supposed to have, they could be in the property, is what you're saying?
Yes, sir.
Okay. Any thought about just looking at some expedited judicial proceeding as opposed to leaving this to the police department?
Delegate, once the bill leaves here, it's now the work of the committee. I am completely amenable to any of those kinds of things that would help move the ball forward because I do think it's a serious issue. So yeah, absolutely. I would be amenable to that judicial process. I'd be amenable to any other discussions as well that could help move the ball forward with this issue.
Okay, thank you.
Thank you, sir.
Mr. Chair, these are actually great questions. So I had a constituent who had one of these issues once. They showed a home, someone left the window unlatched, and one of the people touring the home subsequently came back and squatted in the property, and that's how they got in. Is that what your constituents are telling you? Can you kind of comment, is that what you're seeing here?
So in one case, for one of my constituents, yes, that was the issue. Essentially, someone had forced entry into a home and provided, fraudulent documentation to someone else saying that they were, essentially the lawful owner of the property and they could, occupy that space, that sort of thing. So that certainly could be the case here. I think there are other instances that you will find out there where someone is, not even yet moved into the property, but they might have, put a down payment down or something like that based upon, a fraudulent document that they've been given a lease or something like that. So they haven't even gained access, but they're thinking that they're, renting a property rightfully and legally, that sort of thing. And so they have not physically been in, but there are certainly instances where people are physically in the property.
Delegates Phillips and Embry had a great point about the eviction, but in looking at the bill here, this bill does something that I haven't seen in our statute anywhere, and it kind of goes after the chronic person who's doing this. They're doing this chronically, they're squatting, they're making some sort of money off of a fraudulent deal. That looks to be a good portion of the bill. Can you comment on that? We haven't touched on that.
Absolutely. That is, I would say the meat of the bill is that. It's certainly, there's other parts of the bill, but the meat of the bill really is to get after, in many cases, even what seem to be sort of criminal enterprises, organized enterprises that are creating these kinds of documents. And I don't want to say they're doing it without impunity, like with no punishment, but there clearly needs to be more of a disincentive for folks to create these kinds of documents, not only with respect to protect property owners' rights, but to also protect people that are victims of these fraudsters.
Delegate Simmons had a huge point that we do know this is a huge problem. We don't necessarily have numbers. Someone tell me, is it a motion to repossess? Is that the motion when we have one of these situations?
Take that one.
When you have a squatter, you want to evict, there's a motion the courts have to take. I believe it's a motion to repossess. I just wanted to bounce that off you. In any case.
A wrongful detainer action? Is that what, I'm sorry, are you referring to the wrongful detainer action?
It might be.
Yeah, that would
Okay.
be the action for a squatter on the
Okay.
civil side.
Is there actually any kind of criminal charge that we have in these situations where we could look at that and say, we have these crimes, we could look to the clerk of the court and say, we've seen these charges pressed, and that's how we know there are X number of these cases in the state. Is there any actual criminal charge that we can refer to?
Sure. Delegate, I think it depends on the situation. Clearly, if someone has broken into a home, there is a criminal charge that could occur in that circumstance. But I think that the way that the law is currently constructed with respect to some of these other circumstances, it is tough to kind of get after these folks currently with the way the law is written.
There's nothing like Delegate Simmons is referring to. We're kind of working with breaking and entering, or nothing specific to this particular kind of fraudulent.
That's right, Doug. We're working with breaking and entering. We're working with trespassing, those sorts of things, which of course are already on the books, but clearly are not sufficient enough to deter some of this kinds of behavior that's occurring.
Thank you.
I have a couple questions, and then I'll go to Delegate Conway. Why isn't this theft?
Yeah, Mr. Chair, I mean, it certainly could be identity theft or some
No,
other.
just straight up theft.
Certainly could be, Mr. Chair.
So 7104B, unauthorized control of property, it's by deception. A person may not obtain control over property by willfully or knowingly using deception if the person, 1, intends to deprive the owner of the property, which check, 2, willfully or knowingly uses or conceals or abandons the property in a manner that deprives the owner of the property, uses, if it's leasing it to squatters, I think, check, uses, conceals, or abandons the property knowing the use, concealment, or abandonment will probably deprive the owner of the property, check, and that's an or, so it can be any one of those three things. The theft statute has different penalties depending on the value of the property. And if the value of the property is worth more than $100,000, it's already a 20-year penalty. So I think under this, at least conceivably, you may actually be lowering the length of time. The public defender nearly just jumped out of her seat and doesn't know what to do. But having said that, but you may actually be lowering the penalty in some of these cases because I think this is theft. Why isn't it?
Mr. Chair, that's a great point. You certainly know the judicial code.
Don't go. You don't get off that easy. No, I think this is one of the questions that kind of has gotten picked up along the way here is I wonder whether there is existing law that covers these things and people just aren't using the existing law to be able to address these specific issues. But
Mr. Chair, and that is a very fair point. But I would argue that, are you really stealing the home by being in the home? Maybe you are, maybe you're not.
Yes.
Again, and that's fair.
You're
clearly
using the property, and property explicitly in 7101 says that it includes real property. You're using it knowing the use will deprive the owner of the property. If you lease it to somebody else and you're using deception, now, if there is a reason, if there's case law that I am not aware of, and it's totally possible, I genuinely don't know everything, I'm happy to hear more details, but I'm kind of wondering why this? And so, and if you don't know, we can look into that a little bit more.
Yeah, and certainly, Mr. Chair, I'm not an expert with respect to that area of law there, but I would say that, the fraudulent documents piece is a little bit different inside of this legislation than what I've seen for some others. And I think that is something that seems to have an issue inside of law right now. Now maybe there is something that deals with that, but maybe it's not strong enough, or maybe we're not enforcing it in the right way. But the fraudulent documents piece seems to be at the heart of these issues.
That may be distinct. I think the issue that came up a couple times in your testimony was that of squatting. So that is kind of where I went, but I'll look again at the other parts of the bill, specifically with the documentation part. Oh boy, look what I've done. Delegates, Conaway, Sample Hughes, Boucher, and then second bites of the apple. Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. My question is about number 2 on the, what do you call this? The fiscal and policy note, where it says establishes procedures under which a sheriff's office must remove a person who is allegedly in violation of these provisions. Is that implying a squatter, or does that imply someone who has obtained a false lease, or both?
Delegate, I guess it could be either, but the bill does not say must in that case. So I didn't understand that in the fiscal note, because the bill doesn't say that they must do so. So I didn't understand that in how the fiscal note was worded. I understand that that's what the fiscal note says, Delegate, but the bill itself does not say must.
So you want that to be may?
It is may. It's not must right now.
Okay, so in reference to this bill, the sheriff's office may remove a person. Is that right?
Yes, Delegate.
Okay, thank you very much. You've clarified that for me.
This is Delegate Naraki's first time in front of our committee. I hope he's enjoying it. Delegate Sample Hughes.
Thank you, Mr. Chair, and thank you, Delegate, for the bill. Mine is not as specific as our chairman, but my question is, in reading the fiscal note, did you already have an opportunity to speak with the Office of the Public Defender to see how they arrived at the number of 450 additional cases?
I have not yet had a chance to speak with the Office of the Public Defender, but I'm willing to speak with anyone and everyone about the bill and, to look for ways of improvement on the bill.
Okay, yeah, because it doesn't have like a huge fiscal note, but I'm just curious, is that maybe the basis of, just giving you an idea of how many cases it might be, or I'm just curious how they arrived at 450.
I will follow up with them, Delegate.
Thank you. Thank you, Mr. Chair.
Delegate Boucher.
Thank you, Chairman, and thank you, Delegate Naraki, for bringing this bill forward. The chairman mentioned case law, and it always makes my ears go up. I'm wondering if there's any case law out there that allows the owners to get a financial judgment against the squatters to reimburse them for the loss of rent or the time in the property. Is there any judicial oversight on this?
Sure. Well, obviously, this bill doesn't say what the courts may or may not do with respect to that. Obviously, anyone can bring an action in a court, and they can seek financial damages, in situations like this or any other kind of situation where you might be able to sue someone for financial damages. So it doesn't preclude someone from being able to seek those damages.
Thank you.
Okay, second vice delegate Eric, and then Phillips. Then I think we're going to move on.
Thank you, Mr. Chair. So yeah, that piece is hard because obviously most of these people don't have money, and you're going to be shelling out cash for the lawyers. But my question was more about, like, I've had 2 of these cases. One of my personal friends found his own building listed for rent and set up an appointment to go see his own building with the scammer. Yeah. So, and I'm just thinking along the lines of theft versus a lot of these situations, because there's no quick ability to get these people out, people are just writing them checks, and they know that. It's a whole scam of just getting a check written to them. Mm-hmm. So to me, if there's not a quick enough solution, there's got to be some kind of secondary punishment on the line, right? That's probably why you put that other piece in that.
That's right.
Yeah, because if I'm the homeowner and I have an inspector coming tomorrow to sell my home, I'm like, how can I get this person out right now? And the only way you can do that is by writing a check if you have the means to do so. So we're just, yeah, so it's undercounted. So we don't know who are these people. We can't count all the times this has happened because the 2 cases I know of are not going to be counted because they didn't end up in court. And on top of that, there's no penalty on the back end for these people that are serially doing the same thing, the scam, putting up a new Facebook ad for somebody else's property and then scamming the owner out of rent and whatever. Isn't that so? Don't you think that's why you included that? Yeah. It's early, but I'm already there. I'm already there.
Delegate, I certainly appreciate the question. To your Delegate, to your point, I think that, and to the chair's point, I think that certainly there potentially is issues of theft here, but I think that the law, how it's currently constructed, is not strong enough of a deterrent in these circumstances, or else we wouldn't see these issues kind of continue to pop up, not only in Maryland, but around the country.
Oh yeah.
Thank you for the second bite at the apple, Mr. Chairman. On the theft piece, that's intriguing to me, Mr. Chairman. But the concept of theft itself generally talks about moving something and taking it permanently. The challenge that I have is timing. One of the things about justice is the timing. And so if it's a theft matter, once again, I'm back to who determines that it's theft. And at the end of the day, if I arrest the person, does that get the person their property back immediately? And how do they make a determination that I should arrest them if there is a debate about whose property it is, right? So I'm back to how do we work with this to speed the process up? Because people, and not only here, but and that's my question, right? And you've got experts here that deal in the housing industry. My question would be, how do we speed all of this up?
Sure. Delegate, I'll go, and then if any of my colleagues on the panel here want to offer some thoughts. But that was at the heart of why I looked at this legislation, because that instance I was telling you about in my district where, someone, the sale of their home fell through because we could not expedite the process enough. And that's where the language came inside of the bill to allow for that sort of expedited process with the sheriff. But maybe that's not the right approach. Maybe the approach is an expedited process in the court system. But to your point, I think that somehow the process needs to be sped up where, in this case, this family didn't necessarily have the means to have, their house, the sale fall through and kind of wait all those extra months to, have that situation resolved. So we could really have, there's the victim that is potentially being defrauded here by being given a fake lease, but I think we also still need to think about those property owners that, like my constituent, that, their whole life could be destroyed, financially in a circumstance like this. And so that's why I was looking to kind of try to allow the sheriff's office to have an expedited time frame, but maybe there's another way as well.
Any other thoughts?
I think it does somewhat depend timing-wise on the circumstances of what type of squatting we're seeing. If someone has broken into a house that's under construction, or that was maybe someone's second home, maybe having them out right then and there is not as much of a priority for some folks as it would be, I came home from vacation and found someone in my home, in which case I want them out 5 minutes ago. Or my new renter or my new buyer has all of their belongings loaded on a U-Haul and is waiting to move into this house and can't. So, I think that there are really some instances where timing and quickness and swiftness is vital in these situations.
Yeah, I guess the only thing I would add, Delegate Phillips, is, right now, there is a housing crisis. There are people that need homes, but at the same time, we have to know who are in those homes for the safety of the other tenants and the community. So that's all we can really, that's why I think that this bill would be helpful in assuring that we get those bad actors out of those communities and make sure that we have some semblance of safety for our residents.
Thank you.
Thanks.
Delegate Schmidt, and then
Thank you, Chair. I know we talked about this extensively last year. I believe it was House Bill 693 that addressed some of the renter rights and stabilization. My question is for Lisa May. Could this bill help prevent the amount of eviction filings that are putting a burden on our courts and on our sheriffs?
To the extent that these cases do get to the court system, as opposed to some of the other, trying to resolve it before it gets to that lengthy court process, it could. We've also discussed, Delegate Naraki and our organization of, really we do need some more awareness out there of how not to fall victim to these leasing scams in the first place. And perhaps, the Office of Tenant and Landlord Affairs within DHCD could be an opportunity to do that so that we kind of prevent this more on the front end as opposed to when someone is already in a home.
Okay. All right. Thank you.
Thank you all very much. We have two other people who signed up to testify. One was, I think, Councilman David Marks signed up to testify virtually. He is not online. Also, David Brand, come on up. So we'll hear from Mr. Brand and take questions for him, and then we'll go to the panel in opposition. So please have a seat, and we'll hear from you. You have 2 minutes.
Hi, how y'all doing? I appreciate you taking the time to listen to my story. My story is a very personal story about what happened to my wife and I in Baltimore County. About a year ago, we had invested in renovating a property to sell. We put our life savings into the property. We financed our home. We mortgaged our home. We spent till 3 o'clock in the morning renovating and working and building and creating a property that we could sell and hopefully make a few dollars on and put it toward our retirement. Friends of ours have done it, and we invested everything that we had. We took a second mortgage on our house. We did everything the right way. We had the property finished. It was a beautiful home. It was in Baltimore County. We had listed the house for sale. We had multiple contracts. We were very excited the house was going to sell, and we had a contract come in. We had a buyer. We were 2 days from the home inspection, and someone had drove by the property and said, hey, there's a moving truck in your driveway. And I said, no, they're not supposed to, the new buyer's not supposed to move in for a month. That can't be. Better go check it out. So sure enough, I get there, my real estate sign is gone. The lockbox was cut off of the front door and gone. There's 2 people in the house and a couple pieces of furniture and a moving truck. I came to them, I said, what are you doing in the house? It wasn't the buyer. So what do you do? It says, oh, well, we rented the house. We got it off Craigslist. This is our house. I said, what do you mean it's your house? You're not the buyer. He said, this is our house. He says, he showed me, we have the key to the house. We have possession, and we have a lease agreement. This is our house. I'm calling the police. So 10,000 cops come, and the police are there, and we're going over with the police. The police looked at everything. He had stolen, they removed the property sign. They stole the key to have possession. They made up a fake lease agreement, had all my information on it. I mean, which you could get online, but it was the best looking lease I'd ever seen. Everything was just on the lease agreement. The police officer, there was like 50 cops there. It was for hours. We pleaded with the police. The police were like, look, I know what you're saying, and we understand exactly what the situation is, but it's a civil matter. There's nothing we can do for you. I'm sorry. I pleaded with the cops, nothing I could do. I went back to the guy, and the guy just said, well, we're just going to destroy the place. We're going to destroy the house. We're going to have fun. If you try to force me out or get your friends or do anything, we're just going to destroy the house. So ultimately what ended up happening is he blackmailed me for $9,000 because he told me that was the money that he had supposedly gave the person for the security deposit and gave the person for the first month's rent. And I said, well, I need you out now. He said, well, I need $9,000 to be whole again. We looked him up later. He had 20 evictions on his report every 30 days. They knew exactly what they did. They knew exactly how to do it, and we were helping.
If you would begin to wrap up, I'd appreciate it.
Do.
Okay, I appreciate that. Are there members of the committee who have questions? The Vice Chair.
Thank you for coming in and sharing this story, this horrific story. So can you tell me, on that day when you got there, you were told that there was nothing that could physically be done to remove the individuals from the house. Is that correct?
Yeah, they told me it was a civil matter, that they had a lease agreement, they had possession of the property, and it was a civil matter. There's nothing they could do.
Okay, and so then after that, was there any civil action taken? I'm not blaming you in any way. I'm just asking.
I have all their information. Yeah, I could potentially sue them, but you know, these people are grifters. They have nothing. They have nothing to lose. And what would I do? Get a judgment against them and try to chase them down? It would probably cost me more to chase them down and get a judgment than it would to do, you know, to try to get it, because I never get it from them.
Okay, and then I hope you heard some of the testimony, and I can't give you any legal advice, and I won't try to give you any legal advice, but I hope you heard some of the testimony today on some of the options that you have. One more quick question I wanted to ask you is, how does the situation stand today with your property?
Oh, well, I paid them the money, they got out, the house settled, you know, life went on, you know, we were, you know, terrified. I mean, I thought we were going to lose everything.
Right.
And we were powerless, and the police were powerless. And, you know, with these people, I don't care whether they give them a year in jail or 100 years in jail in terms of how the law works. They just need a mechanism that allows the property owner to show to the police, to give the police the authority to remove them. And look, if I was lying and they were a tenant that was a bad dispute, and I called the police on them with some law that got them dragged out, they could come and sue me for everything I own. They could sue me for the property, for damages, for everything. So no one's going to risk that. But if I make a statement to the police and give them the authority to remove them on the spot, and they have nothing to come back on because they know what they did was illegitimate, then the law works.
Mm-hmm. Mm-hmm. But can I just one more quick question? So my understanding on this particular bill, the persons who were in the property would produce evidence that they are supposed to be in the property. And then at that, I mean, we're literally at the site when you called them and the 10,000 police officers came, you'd be sitting there, and I know you were joking.
Yeah, no, I know.
But my question is, they would present their lease that you said looked like it was legal and all that, and you would present perhaps, maybe you might have had your sale.
A deed or proof of ownership.
when you sold to the new buyer who hadn't been there, and maybe you would have had a letter or something. But all of that you would have had to have at the property for it to work under this particular bill. Is that your understanding?
Well, you know, my opinion on how they wrote the bill, I think there's probably room for improvement. I'm not a legal expert, but my understanding is that New York and Florida's bills have some language in there that does address that exact question of if the property owner proves he's the owner and the police act on what the property owner tells them, that if the property owner isn't representing himself, then he himself becomes culpable or could be sued damages from the person he had evicted. So if it was a legitimate case, he's a property owner, he gets the guy out, and he does it improperly, then that person come back for him civilly, and he could end up owning the house.
Gotcha.
So that would kind of prevent someone that would make someone in my situation go forward and sign the affidavit and say, I want him out today because I know there's no recourse. Get him out right this minute. There's no recourse on it.
Okay. Well, thank you
have to take that
again.
risk.
Thank you again for coming in.
Okay, thank you.
Delegate Conway?
Mr. Chair, thank you for coming in to testify. How did you find out who the person was? After you paid them the $9,000 or before
Well,
that?
when we got there, I didn't know who he was, of course. When I got there, the police came and the police got his identification and they did their part of their investigation. And then at that point, I was given a copy of the lease agreement that they had fabricated, which had their names on it. I mean, it was the best lease I've seen. It had
Okay,
all the
I
information.
got you on that after a short time. But you don't know that that the name that was on the lease was the actual person?
Yeah, the police verified that.
They verified that and
Yes.
told you
Yeah,
that is the person?
police verified their
And,
ID.
but they wouldn't evict the person?
No, they couldn't.
All righty, thank you.
Seeing no other questions, we thank you very much, sir. Councilman Marks is joining us now. Can you hear us? Yes, you can.
Yes, I can.
All right, so we're going to give you 2 minutes to testify and go ahead, and then we'll take questions for you. Go ahead.
Well, thank you very much, and I will not need my full 2 minutes. I just wanted to offer my support for Delegate Naraki. Delegate Naraki works very hard in our communities, and we dealt with this squatting issue throughout our shared district. We both represent the Perry Hall, White Marsh areas, and I just wanted to lend my support toward the efforts he's trying to make here. Thank you very much.
Okay. Any questions about Councilman Marks's appreciation for Delegate Milwaukee? Delegate Kaufman.
And I appreciate all of you. Thank you very much.
But my question is this, sir. I mean, there are certain sleazy people like the poor person that person dealt with, that had to deal with, that the past witness had to deal with. But isn't this sort of a broader issue, though? Because 99% of people wouldn't want to squat, but they're homeless. So isn't there a broader homelessness issue here?
There may be a broader homelessness issue, but I still think we should have penalties for those who produce counterfeit documents. You know, we're all public servants trying to deal with that issue, but I think it's a very clear-cut case here.
Okay, thank you.
Now we're done. Thank you very much, sir. Thank you, Mr. Brand. Thank you, Councilman. And that concludes the testimony of those people in favor of the bill, and the committee has officially knocked the rust off with 50 minutes. All right, so now we're hear those in opposition. Joseph Lovelace, Elizabeth Hilliard, and Albert Turner are here in the room, I think. And then we have one virtual person, Jessica Legette. All right, we'll ask the virtual person to be brought up on the screen, but we'll start with whomever would like to go first. And they're conferring, and if all else fails, I'm going to start on my right and go that way. Who would like to go first?
Thank you, Chairman.
All right, on my left, and we'll go that way. Go ahead, sir.
Thank you, Chairman. Albert Turner, the Public Justice Center, also members of Renters United Maryland, coming in opposition of House Bill 202. So we understand that there is, and we get a lot of calls from people who have been scammed in this idea of thinking they're leasing a property, and they come to find out that the property that is being leased is actually not from the owner. It's from a scam artist that they found on Craigslist. That happens a lot, and we're seeing that a lot. What this bill would do, though, would harm them even more, because it would effectively give them no notice, have no type of hearing in front of a judge or court, and effectively kick them out, right? So as the bill as constructed is, anyone with a signed affidavit can go to the sheriff's office and say, I own this property. There's nothing in the bill that says that they need to have a deed, they need to show any type of other information that they own the property, just an affidavit saying that they own the property, and the sheriff shall remove that person, right? That is what the bill effectively does. And that creates a lot of constitutional issues There is no notice in that. There's no procedural notice, but it also effectively further harms the person that's being scammed. Person believes that they are in good faith in possession of this property as they believe so. A sheriff comes on the door, says, hey, I have this affidavit saying that you don't own this property, you need to get out now. That further harms that person. And so we find the 2 points of the bill kind of in conflict with each other. And because of that, we are in opposition. In addition, this does create a lot of havoc for sheriff's office, in our opinion. Essentially, what the sheriffs would be doing is be the judge and jury and fact finder. They are the ones that would have to take, if someone says, hey, I have a lease, I believe this lease is legitimate, the sheriff has to take this, they have to compare it with the affidavit, they don't know what to do, and they have to, at that moment, have to figure out what to do at that moment. That is something that cannot be done under the Constitution and under other legal precedents. So for that reason, we are in opposition.
Good afternoon, members of the committee. My name is Joseph Lovelace. I'm a staff. Can you hear me now? Good. Good afternoon, members of the panel. My name is Joseph Lovelace. I'm an attorney with Maryland Legal Aid. I regularly represent tenants in landlord-tenant eviction proceedings, including wrongful detainer. And what I can say right now is, and I think our chairman already understands this, Maryland law already provides a remedy for those seeking repossession of their property if there's a squatter in there. It's called a wrongful detainer. It's in 14132 of the real property article. And I see these types of cases all the time. And what makes them so difficult is in situations like this where there are scams involved, the person may be in wrongful possession due to no fault of their own, but because of some third party. But what this bill does, in addition to these penalties, which the chairman indicated might be less than a charge for theft, is a summary eviction where the sheriff knocks on your door one night, you've got no idea they're coming, and says, hey, I've got an affidavit that says you're here wrongfully, get out. The best way I could see this possibly going is the person says, I'm sorry, sheriff, allow me to go back in my house and grab a copy of my lease or something that says I'm there. Now, we've just put this sheriff, this deputy, in extreme peril. Because what if they don't come back with a lease? What if they come back with something else? It's entirely foreseeable. And this is why these types of laws should not be passed by this committee, why we are so unfavorable to them. Forget about it working perfectly fine. You should still end up with someone out on the street who may have no reason to be there, but for lack of any judicial process or notice that they were going to be confronted in such a manner, finds themselves out on the street. This is a dangerous bill, and that's why we're in opposition to it.
Thank you, Chairman, committee, nice to see you. The Office of the Public Defender is also requesting an unfavorable report on this bill. And for good measure, also House Bill 154 and House Bill 164. I know there are a lot of bills today, so we're trying to minimize our testimony. I just want to highlight the story of 3 families that we've worked with who were victims of the fraud scam that were displaced and actually put in danger when they were displaced. One of them, we had a mother who was disabled who had 2 small boys living with her, and she had been, what she thought been provided a lease and a place to live. She had a name for the landlord and a phone number, but that was the only contact information she had. And there were safety issues with other individuals trying to break into the house while she thought she was rightfully living there. She contacted the police, contacted the landlord. The number that she had originally received from him was no longer in service, and it became a very complicated situation that eventually led to her having to find a new place to live, which was very difficult for her because she was on a fixed income and had very little funds available after she had been paying rent to the original landlord. Similarly, we have seen other individuals who have been victims in this instance where they have actually registered their children in new schools, have moved to new areas, thinking that they are starting, a new life, and then only come to find out that the rent they've been paying isn't actually going to the person it needs to be going to, or the property itself is unavailable. And I just want to highlight to Delegate Sample Hughes's question, our fiscal note numbers came from the Baltimore City Sheriff's Office. They gave us the number of 100 pending wrongful detainers in August of 2024, and we extrapolated from that.
Can we have Jessica Leggett? Are they? There she is. All right. Go ahead, please, for 2 minutes.
Good afternoon, everyone. My name is Jessica Leggett. I'm a Baltimore City resident and a mother of 3. During the pandemic, I asked my landlord to fix some lead issues in my home. The landlord retaliated against me and kicked me out, which left me to scramble to a new place. Moving in a short period of time, my family and I were in a tight spot financially. I was so relieved when I found a place in my budget, especially because the landlord told me I could move in right away. Unfortunately, this is the beginning of my trauma. Right after moving in, random individuals started coming to my place saying they owned the property and wanted me to leave. None of them told me or showed me any proof of paperwork. It was scary and confusing. I did not know who to trust. I realized that the person who had rented me the house had never owned it and had scammed me out a few $1,000s. It would take a long time for my family and I to recover from this anguish we experienced throughout this time. My kids are suffering at school. I have been diagnosed with PTSD. The only thing that has helped me throughout this time is the legal advice. I had the right to a court process. They helped me understand that the aggressive strangers who kept coming to my door weren't entitled to throw me out at that moment. I soon faced a wrongful detainer case. The actual owner had to prove that he was the owner throughout the court process. The judge gave me some clarity about what was going on and the little time I had to move out. The little time was crucial for me. For the company that owned this property and many others, the house was an investment to be checked on every couple months. For me, it was a home for my family, a stable point. The city had issued this property a vacant building notice years before. I wish the owner had boarded up the house back in 2022. Then I would never been a victim of this scam. If HB 202 had passed, a sheriff would have kicked me out into the streets at that time, and I wouldn't been able to get my belongings. That's terrifying for me and my family.
Right. Thank you very much. We're going to take questions for the committee. Delegate Arikan.
Thank you, Mr. Chair. Thank you guys for being here. So my question is for the Public Defender's Office. I hear this is terrifying. This is exactly what almost happened to my friend who was literally almost re-rented his own property. So, but for my constituent's case where they already had that list of 20 prior, what's the appropriate penalty? What can we do to appropriately penalize the people that are just serially creating these scams? What would you guys say would be the appropriate penalty?
Thank you for that question. I think I would never advocate for criminal penalties just because of my role. But I think, I gave the delegate my card. I'll highlight 3 different things. So the first is my concern about this bill is it is problem shifting as opposed to problem solving. We're not actually solving affordable housing crises, homelessness crises, or the fraud crises that is allowing this to happen. I mentioned that we have had the Baltimore City Sheriff's Office had highlighted this issue for us, and we had talked we, had talked about like a registry, notices, ways to try and cut the fraud off as opposed to, because of course, obviously that's horrendous, that experience and that loss and would be both terrifying and awful.
Yeah.
And I do think that there are a lot of criminal statutes in place that would apply to that individual.
The time frame is the biggest.
And I think that if we want to have a conversation about making wrongful detainer processes faster, I will say fortunately / unfortunately, we don't actually handle housing processes.
Right.
But if there was that judicial due process component, I think that would really alleviate many of our concerns. And if that was a process that could be expedited safely, like I think, that would be helpful. And I will also say that, I think I forget who mentioned this on the panel, but really looking at preventative options to make sure this doesn't happen.
So maybe something like how the IRS has like a PIN. I've had somebody fraudulently file my own tax return. So my accountant said there's a PIN system now, something like that, where the owner of the property could go in and the tenant would have to put a PIN in if they want to, voluntary, but at least it adds a layer of protection if you're in a community where this is a common scam.
Yeah.
Okay.
So we would be happy to discuss options of those natures. Yeah.
Okay. Thank you.
And if I could, I know that there's been discussion about this topic. I know that we've talked with the Baltimore City Sheriff's Office a lot. I know that there has been a lot of discussion as to registering these type of properties so that if the sheriff does know whether or not this person is scammed, that there is some type of PIN system or some type of way to identify exactly who is the rightful tenant in possession or the owner in possession. Just for this bill specifically, I think this bill creates a lot more issues as is, because I actually kind of think this might actually create more fraud, because the person says, all I need to get possession of some property is to sign some affidavit and show no other proof. That could be something that could happen. I don't know.
Oh, interesting. So your theory is that someone would fake ownership by creating a fraudulent, but they also have to show a deed. So I guess they'd have to have a fake deed and a fake
as far as I know,
forged
nothing
affidavit and be like, I'm just collecting all these properties now.
As far as I know, nothing in the bill requires anything else aside from a signed affidavit.
Interesting. Okay, thank you.
Further questions? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in. Do you know, is there any penalty for showing a law enforcement officer a fake deed or fake lease?
Yeah, I'm sure there is. There's plenty of crimes.
You sure there is, or is
I'm sure. I mean, that's fraud, right? That's fraud.
I'm asking you. I don't.
I'm not a criminal expert, as far as I know, but as far as I know,
thank you.
I'm sure there are other answers.
So I do have an answer, and it's I think it's Criminal Code 8601. The fraudulent deed as one of the things you can be charged with. So if you were to show a police officer a fake deed, now how is the police officer going to know without at least checking land records, I would think that this is fraudulent, which is a part of the reason why we think this should be in the court system, where judges are more attuned to the rules of evidence and what looks real and what isn't.
So once you go to court and it's proven that the person showed a fake deed, then what happens? Is there a warrant issued for the person's arrest? Does it turn back from civil into criminal?
So that's where
you
there is an overlap here that 8601 and the criminal code isn't what I deal with. Like I said earlier, I handle the civil side, so wrongful detainers, and that sort of issue. I can tell you, I don't think I've ever in my 3 or 4 years of practice ever seen a fake deed.
You're hearing testimony. Did you hear testimony today about fake deeds and fake leases?
I heard testimony about a fake lease. I'm telling you that I personally have not seen
All right.
one.
Thank you so very much for indulging. Thank you.
Vice Chair. Vice Chair.
Thank you, Mr. Chair, and thank you all for coming in today. So I liked something I was hearing about perhaps we could speed up the wrongful detainer process as a possibility. Ms. Hilliard, you mentioned that. What is about the average time now? I mean, it's pretty long. I hear it's long, but I don't know what it is.
And that's a great question. My understanding from the meetings we had, so just to And again, this is out of my bailiwick, so I had to do a lot of research, but Real Property 14132 is what provides the current procedures for wrongful detainer actions. And my understanding is that it's meant to be about 14 days, but that, for example, in the Baltimore City Sheriff's Office, they were seeing longer delays because they were still operating on a fax delivery system for the documents that were necessary. But my understanding is also that they fixed that problem now. But so again, this is kind of anecdotal for me, but the codification, there's about a 14-day period in the law, and it typically takes a little longer than that. I think 21 to 30-ish days is what they're seeing.
Okay, I think that's as far as I can go for right now. Yeah, I think that's as far as I can go. I was looking at New York, and I see some problems with New York too, but maybe we can. So thank you for your answer.
If I might add one thing, there's no prejudicial notice in a wrongful detainer action. So what it takes to get a wrongful detainer action started is you go to the courthouse, you fill out the court form for a wrongful detainer, you fill it in, the sheriff posts it, and then you have a court date. You then show up to court, presumably with your deed or whatever document of possession that you have. And once you show your deed, 9 times out of 10, the other party's not even there. You end up with a judgment that the sheriff can then enforce. So the process that already exists is quite good. Now, do all property owners know about the process? I don't know. It doesn't sound like it. But we do have a process to address exactly this problem of people taking possession of properties that don't belong to them. And I would advise they use that method.
And to add that point, there are damages that you can collect in wrongful detainer cases as well. So you file against someone who's in wrongful detainer, they tear up the property, you could always get damages on that and through that complaint as well.
That would address your concern about due process with the wrongful detainer action that we were just talking about. Is that correct?
That is correct, Your Honor. I think.
All right.
Excuse me.
I got one.
I'm in lawyer mode. I apologize if I. But if I can just.
I usually just like people to bow.
Curtsy.
But if I can, I've dealt with a client who they are looking at a wrongful detainer because they signed a lease through a owner of the property, and come to find out that the wife, who also is a joint tenant in ownership, they had some marital issues, and now she doesn't believe that the lease that they signed is legitimate and wants them out through a wrongful detainer. These are some kind of interesting facts that need to be brought before a judge, have evidence be heard to show exactly what is the agreement between this husband and wife, and actually what was the agreement between the leaseholder and the tenant. Right. And that's the reason why we believe that should be heard by the judge.
What else? Seeing none, thank you all very much. Thank you for joining us virtually, and that concludes the testimony on our first bill of the 2025 General Assembly session. It only took 70 minutes. House Bill 202. We're going to go now to House Bill 179. Delegate Tolles, who would you like to be on your first group? Locklear, Shoemaker. I don't see the state's attorney. The state's attorney, Ms. Barry Boy, is not here? Her office is here. Okay, well, let's do that. Let's stop there, because then that leaves 4 to call, and it'll be an even balance. Let's go ahead with these 4, and we'll go to the next right after that. Delegate Tolles for 3 minutes, please.
1 second, Mr. Chair. I need a second. Sorry.
Court's indulgence.
I'm sorry. What did you say?
Is it? I didn't hear. I'm focused.
Go ahead.
Chair
3
Clippinger,
minutes.
Vice Chair Bartlett, and committee members, I am asking for your support again this year on Organized Retail Theft Act, House Bill 179. In the 2024 session, we passed this bill unanimously out of the committee with the help of our magnificent chair, who I know would do it again. Unfortunately, we got stalled by our friends in the Senate. They always, do that sometimes to our bills. But retail theft needs to be a priority this year. The impact Maryland retailers alone who lost $1.4 billion in revenue translates to about $29.21 per capita. And you all know we need this money in the state. Small businesses constituting a vital component of our economy are particularly vulnerable, with 75% reporting monthly profit losses ranging from $500 to $2,500. It also increases the burden of prices to compensate. It increases the prices, the burden on the community, on the shoppers to compensate for these losses that are impacting them. According to Prince George's County Police, we averaged about 125 to 200 reported thefts per month, and that was in 2022. I talked to you last year about a couple from Ulta Beauty who stole $6,400 and traveled from county to county, stealing nearly $160,000 worth of goods. Stores across Maryland are locking up their items on basic household items, making it inconvenient for our constituents to get things like deodorant. Y'all know people need deodorant, right? Detergent. Y'all definitely know folks need toothpaste. Why are they locking that up? This is unacceptable in our community, and our businesses and residents deserve better. Recognizing the severity of retail theft in 32 states have already enacted new organized retail crime laws. Even progressive states like California had a sweeping package of bills. In conclusion, I urge my committee to consider the significance of HB 179 as a potential to safeguard our economy and our state. Our communities should be able to thrive. Again, we need the money in our state, and theft impact businesses, owners, shoppers, everyone. So many constituents have expressed concerns about this. And so we need this tool to hold perpetrators accountable. I will say one thing, go about 5 seconds over, Mr. Chair. The Public Defender's Office in a letter, and I love them. I got a couple bills I'm working on with them, so I love those guys. But I do slightly disagree with the fact that we have something already on the books. Yes, if you're in Ulta Beauty and you're going only in Ulta Beauty, but that's not organized retail crime. Yes, you can deal with that one particular store. But when you start talking about going to Target, then going to Walgreens, then going to Ulta Beauty, it's organized to steal these items with one individual or organized group of individuals, which is more than, it could be two, that's a group. It's still these individuals. We need this law to be able to aggregate these crimes and ultimately deal with the one person regardless of which county they are in. Okay. And so with that, I do want to ask real quick, we have some
you
folks
passed
here.
real quick a minute ago.
Okay, I'm sorry, real quick. Okay, Sheriff John Carr, our chief of Bladensburg here, Collington, Chief Tyrone Collington, Chief Linwood Austin from Mount Rainier, and one of our pastors in our community, Bobby Williams. If they could just kind of stand or wave or something like that, just to let you know that we have support.
Standing right now.
Thank you.
Right behind you.
Thank you,
All right.
Mr. Chair.
Whoever would like to go next, please.
Good afternoon, Mr. Chair, Madam Vice Chair, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. And please don't kill me, but I have 6 bill hearings today, so I would love to be able to leave after questions, so my apologies. Thank you, first of all, so much for your work on this piece of legislation. Last year, our organization has been working on this with you all for 9 years, and we've worked with you and many of your predecessors on it. The bill before you, again, unanimously passed both chambers for the first time last year. It did pass the House after crossover and then didn't make it in time over on the Senate side, as was referenced earlier. The bill merely defines organized retail crime. It allows for data collection as well as theft to aggregate across jurisdictions. You all last year caught something, and you referenced it in the first hearing of today, that is really critical that we missed last year in reference to the felony theft levels with regard to felony dollar amounts. That was really, really important regarding sentencing and fines. Again, 37 states now, including every single state that touches Maryland, has passed organized retail crime legislation. Even California, as referenced earlier, passed a comprehensive, far more aggressive package of legislation. And I think it's time that Maryland move forward as well. I'd also just mention that Maryland's communities truly are being impacted. I just want to give you a stat about what's happening in the pharmacies in your communities. Between 2023 and 2024, Maryland closed 37 of them alone, and there will be more. So we urge the committee to move the bill again, and I'm here and glad to take any questions the committee has. Thank you.
Okay. Good afternoon, Chairman Clippinger, Vice Chairman Bartlett, and esteemed members of the Judiciary Committee. I am Deputy State's Attorney from Prince George's County, Perry Paler, and I'm here on behalf of the Honorable Aisha Brave Boyd, State's Attorney from Prince George's County. We're here this afternoon to support House Bill 179, the Organized Retail Theft Act of 2025. Our office's Special Prosecutions Unit prosecutes, among other offenses, organized financial and economic crimes. These crimes usually involve predatory activities such as identity theft, computer fraud, and so-called Ponzi schemes. The recent spate of events involving systematic looting of our region's retail outlets by identifiable organized crews, often wielding firearms and other deadly weapons, presents an additional insidious challenge to our efforts to enforce the law. The provisions proposed under House Bill 179 will provide a powerful tool for prosecutors to use in confronting this emerging challenge by allowing individual instances of retail theft committed in furtherance of an organized criminal scheme to be joined in one prosecution, even if the perpetrator committed such crimes in multiple Maryland jurisdictions. Otherwise, perpetrators are able to hide behind the legal fiction that each of their retail looting crimes somehow stand alone, without connection to the organized criminal enterprise of which each of these crimes is the essence. For the foregoing reasons, we respectfully urge a favorable report and ultimately passage on House Bill 179. Thank you.
Thank you. Good afternoon, Chair Clippinger, as well as Deputy Chair, Vice Chair Bartlett, members of the Judiciary Committee. I'm Jason Shoemaker. I'm here on behalf of the Maryland States Attorneys Association and the Frederick County State's Attorney's Office to again provide support in favor of the Organized Retail Theft Act, this time of 2025, House Bill 179. Thank you for giving the opportunity to appear before you. What we know is organized retail theft is not committed to meet a need. It's not merely opportunistic. It's planned and repeatedly engaged in with the intention of stealing items to be returned or resold, enabling the culprits to make 100%. The other thing we know, they're traveling hundreds, if not thousands of miles. I've heard of cases from Florida up through the East Coast, people engaging in this type of behavior. So they're not from our communities. They're coming into our communities and they are harming our retailers and even the employees as well as the customers in these locations. House Bill 179 encourages the implementation of task forces between law enforcement and prosecutors to work together across county lines with the retailers, again, enabling all of us to coordinate prosecutions for maximum impact. Further, if this bill passes, when these crimes are consolidated for prosecution, that will conserve judicial resources by placing multiple offenses in one courtroom as opposed to being prosecuted in multiple courts in different jurisdictions. The other thing, these crimes are looked at as one cohesive theft scheme, so trying them in one courtroom just makes sense. Hopefully a few successful consolidated prosecutions will reduce Maryland retailers from being the targets of these types of offenders. We thank you for the opportunity again to speak in favor of the bill, and we urge the committee to issue a favorable report on House Bill 179. Thank you.
Questions for the panel? Delegate Simmons.
Thank you, Mr. Chair, and thank you, panel. This is the last year come back. It's great legislation, and we really need to get this done. Let me ask you this. I had the opportunity over the Christmas holiday to go out to our stores, looking at some of the things that we can do to kind of mitigate that loss. I found that a lot of stores don't prosecute. A lot of them don't even attempt to stop people when they are stealing. Can you talk to me a little bit about what can be done or what is being done to come to the rescue of them currently? Although we're projecting what we want to get done, what is happening now in that space?
So at least on behalf of our office, we're engaging with retailers at a more direct level. So instead of waiting for the police officers to contact us, retailers are reaching out to our office. And if we're aware or become aware, and we've had this happen since I've testified here, when we find cases, I have individuals in my office looking for this type of organized retail theft at the Frederick County level. And then what we do is we reach out to the retailers. We say, we see you have reported this. We're contacting you regarding it. And then we go from there. So in other words, someone may get charged in one incident, and then upon digging into it, we find out they've committed 3 or 4 others in our county, then we'll reach out to those victims, those victim retailers, and at that point, we can begin to build. This has been years in the making, with retailers becoming frustrated with the system, coming back to court 3 and 4 times just to find out the case was jury trial prayered or no-prost or dismissed. And we're trying to reinitiate that communication so that we're all working on the same page with the issue.
Sure, may I have a follow, Mr. Chair? Yes. So how do you mitigate the loss? Is that an insurance claim? Like, so since nothing, it's just a total loss?
It is. And what I've learned is both whether they recover the property or not, many stores have in place a policy that says they cannot then resell that to the public. So even if the property's recovered, they can't
The FDA won't even allow us on some of the property that's stolen.
Sure, thank you.
And you want to respond to the previous point?
May I just add a comment? Thank you. On the retail side, so there are security upgrades that are going on. There are new hires for asset protection or loss prevention individuals. It's the largest, probably growing sector of employees that we're seeing on the retail side. I mentioned last year, our organization made a commitment to hold an organized retail crime conference where we bring together state's attorney's offices. We bring together asset protection and loss prevention individuals as well as law enforcement, and we work with them to train, make introductions. That's very successful. And I'd also just mention that we made this commitment a long time ago, close relationships with prosecutors' offices in every jurisdiction. So when someone is not responding to them, not providing evidence in a timely manner, they give us a ring, and then we get them on the phone and let them know that they need to work with their local state's attorney's office. And finally, I just mentioned you have in your packet a letter of support from every county in the city, in the state. We wanted to show you all every single jurisdiction in Maryland is being impacted, and that support is across the board.
Mr. Chair, just want to add something real brief. Thank you. Delegate Simmons, 2 things. What I'm noticing is that they're asking stores not to even go after the perpetrators for their own safety, right? So they're saying, just let it be. So that's the issue. So then you deal with, retention of employees. The second point I wanted to bring up, what Kaylee mentioned was the security upgrades, new hires, and other ways they have to improve the store. That impact falls back on the consumer, which we all have heard from our constituents. The price of basic items, necessities we need in our home is continuing to go up. So when you have items that they cannot resell in the store, when you have items that are taken, if the store is to be viable and stay open, that will be put back on the consumer. And then our constituents are complaining of the cost. So this is a tool to help deal with some of the community concerns. So thank you.
briefly, Delegate Simmons, I wanted to respond. In Prince George's County, when it reaches a certain level, we aggregate the crimes and we indict those crimes. So now they're moved to the circuit court. We also assign victim witness coordinators to deal directly with the retail stores. A lot of times it comes down to opportunity cost, because in the district court, sometimes our witnesses and store managers might not feel like they're really getting the justice for the time it takes to go to district court 3 or 4 times. But now through indicting those cases, now they're in the circuit court. We don't play the game where cases are continued 3 and 4 times until the witness doesn't show up. And we've had great impact in taking those measures.
And if I may, this is the loophole here. This is the issue. There is a theft scheme on the books right now that already exists, but it can only be applied in one jurisdiction. Correct. And they know that. So they go to misdemeanor theft at the $1,500 level and then jump jurisdiction to jurisdiction to steal what they're looking for.
Correct.
Delegate Simmons? Yep.
So I would be interested to know, like, we're talking about revolving crime here. What does that look like in demographics? Where is that at certain part? Is it all over the state of Maryland? Who's doing it? What is the age group? Certain things that the devil's in the details.
Can I'm sorry, go ahead.
Let him finish his question.
I know, I'm sorry.
She's excited. It's not a fault. So those things are important too, right, when we paint the picture. And also when we look at our prison system in combination with that, when we talk about, how we have a high number of minorities in our prison system, is this a contributing factor?
I'll let the retailers answer about the retailers and the state attorneys answer about the prison system. I was so anxious to jump in there because I talked about this to many folks, and I think it's important where we are in the state in terms of our economic issues that we're having, budget issues, right? You have this is not about minorities, it's about how we are losing resources and businesses and money in the state. Clarksburg, I told y'all I like to spend a little bit of money on some things sometime. I like to shop. I think I said that last time. But in Clarksburg, which is not a minority area, and that's okay, right? Clarksburg Outlet had a theft, a smash and grab. Items were stolen out of high-end stores. 2 or 3 of those high-end stores have closed in the state of Maryland. They no longer exist in the state of Maryland. You have to go to Leesburg, Virginia for those stores. Why should we lose businesses where individuals are spending hundreds of dollars if that's their choice on high-end items they no longer can get in the state of Maryland? So when you look at where it's impacting, it's not really a minority issue, it's a Maryland issue. And I think that's what we really need to look at, because I want to spend my money in Maryland. And quite honestly, I live closer to the Virginia line in gorgeous Prince George's. But if I would drive a little further just so that it can be on record, I'm spending, the state of Maryland want these stores. We're going to invest and spend money in these stores because retailers track where the money is being spent. If no money is being spent in Maryland, they just not going to build in Maryland. They'll just go to another state. So I think that's important to recognize. Not a minority issue, it's a Maryland issue. Thank you.
If I could, Delegate Simmons, briefly, what we also know is that the boosters are not selling the items. They're all being, anecdotally, they're being returned to a central location. So there are people who go out every day like their job to go out and steal and return items to a central location. So in terms of demographics and who we prosecute, our mission would be to use the boosters to get to the central repository where the goods are being returned to, packaged, and then shipped.
And I just add that a critical part of this piece of legislation and where we've run into some issues here is we do track theft in this state. The problem is that umbrella, if you will, encompasses all sorts of different types of theft. So we don't know kind of what's what, and that's really important here. That was added in the bill, which was really important. And I'd also just say, we're on the 95 corridor. We have 81. So you just heard of a massive bust in Hagerstown. I mean, it's truly impacting communities all over the state. Thank you.
Thank you.
Delegate Thomas.
Thank you, Mr. Chair. Yeah, you're right. I mean, this is a problem all over the state. I mean, I know in Carroll County, our sheriff talks about this a lot, especially with the Ulta and Walmart. 2008 or 18, between 8-month span, our police department had to be called for, I think it was 335 times to Walmart, which for Carroll County is a lot of times to be called to a Walmart for theft. But my question is for Delegate Tolles. Last year, you had a very special guest testify. What happened to him this year?
He's at Walmart.
He's at Walmart.
Trying to.
All right, I'm gonna text him and ask why I'm gonna ask why a certain former small town
Country
simple
lawyer.
country lawyer isn't here. So, all right. Just make
Well,
sure.
I would just add, colleague, is that if you look at last year's testimony, I'm sure he will say the same thing. It's not the same. It's not as much fun because he's not here in person. But the argument still stands that we have a problem with retail theft, and he's, like I said, probably at the Walmart trying to figure out how to prosecute those 335 calls that we get. So, thank you.
Thank you.
Thank you for your question.
Seeing no further questions, we thank you all very much, and we'll go to the second panel. Mike O'Halloran, Micah Newmeyer, Kirk McCauley, Farjad Noor.
Okay, that's fine.
Don't care who goes first. You all can decide.
I can jump on that grenade if you will, Mr. Chair.
All right.
Happy to bat lead off. It's been a while.
That's fine.
25
Mr.
some odd years
O'Halloran.
since varsity. All right, good afternoon, Mr. Chairman, members of the House Judiciary Committee. For the record, my name is Mike O'Halloran. I'm here today representing the Mid-Atlantic Petroleum Distributors Association, which encompasses membership made up of not only energy marketers, but convenience store operators like the one you'll hear from shortly. If I could just very briefly give an overview of the convenience store industry, it is going through a lot of changes. It's still the places where you can go and get your favorite snacks, your favorite soft drinks. But as I'm sure many of you can attest to firsthand, is they're also changing their offerings. Prepared food, hot meals, ready-to-go food. But as the industry continues to evolve, so do the issues with crime that they're facing. The issues certainly have always been there, as they do in most retail sectors, but in convenience stores especially, we've seen that crime in our stores has really jumped. And the sort of crime that's being perpetrated is certainly coordinated. Speaking for myself, I've seen footage from convenience store operators, their security cam footage of some of these criminal operations, and when I tell you that they are military type precision, they are military type precision with how they approach their enterprise, if I could steal the term from the previous panel. So it is an organized element that we're seeing in our stores, and it's not just stealing some of the merchandise off our shelves. We're seeing a great rise in the knockoffs of our ATMs. So these issues are serious, and as I mentioned before, you're going to hear from an operator on some of the impact it has on his store, not just in terms of the losses his business suffers, but frankly that emotional element, which I know is so important, particularly here in this committee, but whenever you hear it from a business owner. So with that, I'll conclude and do ask for a favorable committee report for HB 179. Thank you.
Hi, my name is Farjad Noor. I'm a franchisee with 7-Eleven. I have multiple locations across county lines, one in Gambrills in Anne Arundel County and another one in Bowie, PG County. I have 22 employees across both stores. I've had multiple incidents over the last year with crime. In the Gambrills County, where we didn't used to have too many problems in the past, we got hit twice where they came in and grabbed cigarettes, one for $1,000, another for $500. And in the Bowie store, I've had 2 incidents where they came and did a cash and grab with the register. One time they even robbed my employee, took his personal belongings because the register didn't have enough money and they weren't satisfied with what they were getting. Recently, 3 months ago, they came in, took the ATM, they damaged the side entrance on the way in, and we were boarded up on the entrance for 3 months, and we still don't have another ATM back. I've lost thousands of dollars just from the ATM alone, let alone the cash grabs. I'm having trouble keeping, employees because they're scared to work, especially after the incidents where they actually brandish weapons and go after their personal belongings as well. And even in the instance they don't do that, they're very aggressive, they get in your face, and they do threaten you to not do anything. I always tell my employees not to, fight back and let them take what they want. It's not worth it, but it does put a fear in their eyes. And also it makes us look, not safe in the community's eyes where they want to let their, kids just walk down the street to our stores. This is a growing problem. I've been in the industry for 9 years, and in the last 2 years, it has just gotten out of hand. In the Gamma location, we never used to have problems, and just the last year, we've had so many issues. Last year, I have lost in total about $28,000 in retail theft accumulated. Yeah, no, that's what I was just gonna say. $28,000 is not a small amount. It's very significant for us to stay in business and just cover all these costs. And it makes it really hard to, upkeep with the staffing needs and all the other things. Thank you.
Hi, my name is Micah Newmeyer. I appreciate the opportunity to speak today. I'm speaking on behalf of the other 130 franchisees in my market that aren't here today, as my friend FJ is. This issue really affects us because even though 7-Eleven is a very large company, we're a company of small business owners. We're a multicultural company with sometimes these business owners, this is the first business they've owned in our country, fulfilling their American dream. These robberies occur sometimes nightly in rapid succession. I know this because I get a phone call at 3 o'clock in the morning, hey, I just got robbed. And then 15 minutes later, hey, I just got robbed, hey, again, and it goes on and on. The average cigarette theft, I'll call it that for lack of a better term, is about $5,000 in retail, and that comes directly out of the franchisee's pocket. In some cases, I have audit shortages for these franchisees up to $20,000 in 1 quarter. The average 7-Eleven store does not make a lot of money. That $20,000 loss may result in no income for that franchisee at all. Secondly, the ATM robberies are super scary. These are guys coming in, black coats, hats, running in with weapons, putting you on the floor, and often destroying the back of the store if they can't successfully get the money from the ATM. I really appreciate any help and support with this bill so that we can remain the beacon in the night to provide good services, medicine, and everything to our community. Thank you.
My name is Kurt McCauley. I represent service stations and convenience stores in Maryland, and Chairman, Vice Chairman, members of the committee, I appreciate the time to testify. My thoughts are the same that's already been said, but I do want to express one thing. This is not about the kid down the block that comes in and picks up a candy bar and puts it in his pocket, or he does it twice or 3 times. This is about gangs, groups that do this systematically. I've watched videos from one store owner, 3 stores, same people came in, all 3 stores, trash bags, 3 of them. Masks are not unusual nowadays, so they got the video of everything, but you can't tell who they are. They come in, they fill their trash bags, jump behind the counter, didn't see no weapons. They threaten them that they would hurt them if they try to stop them, jump over, fill it with cigarettes, whatever they can get a hold of. Normally it's under $1,500, and they walk out the door. That was on 3 videos that I sat and watched, 3 different locations. So this is not about the kid that just gonna shoplift or something like that, or a person that happens one time. This is about gangs that do it systematically. And this bill, truthfully, there shouldn't be any discussion on it. It's a bill that works. It will work. It'll hold people accountable for what they're doing. And the people that are doing this, when they get away with it, it only enhances. What are they going to go to next? Next, they're going to go to the guns and so forth and bigger things, or to them bigger things. But it's hurting our retailers terribly, and we ask for a good vote. Thank you.
Questions from the committee, Delegate Conaway?
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. In reference to the ATMs being stolen, Is that a federal issue or is that not covered by the Fed?
So it's actually, I remember this question from last year, and I did a little bit of research.
Who asked you last year?
So actually, interestingly enough, our very own Congressman Glenn Ivey put in a bill a couple years ago having to deal with this, because the problem is so many of these ATMs are independently owned and operated, and they are not covered by the Federal Banking Robbery Act of 1934 or whatever. Bottom line is the legislation that Congressman Ivey had at the federal level would have, from my understanding, brought the theft of any ATM under a federal crime umbrella.
Okay, so to make your answer clear, the answer is no. Or not always, sometimes.
Correct.
Depending on who owns the machine.
I believe so, correct.
Okay, and when you said, to the lady that testified, you said sometimes they don't get enough money from the ATM machine, so they destroy the back of the store.
Sure.
And destroy it for what? To take out the safe or?
So essentially, if there's a failure in using the jaws of life to secure the ATM machine and they are not successful getting the money out of there, they'll revert to a cash grab at the register. And there's often retaliation because they're trying to rip out our surveillance equipment in the back of the store. So they rip out that, they take the computer. Sometimes they just bust up the whole back room, make quite a big show of it. And again, that goes to the fear of the employee in that building, as well as trying to attract other people from the neighborhood to feel safe working there.
Thank you very much.
Delegate Simmons.
Thank you once again, Mr. Chair, and thank the panel for coming out. We spoke a little bit about, the American dream and what does that look like. Can you talk to me about what action the store owners take when it comes to theft or loss? Do you press charges? Some people call the police, some people don't. What does that look like when it comes to what are you doing to make sure you're banning people? Like what action? Can you give me a little example of an action of a store owner?
Yes, sir. So we have a standardized asset protection protocol for 7-Eleven. It's a franchise-based business, so as a franchisor, we provide support. So we would call in a case to our asset protection line and call the police. And then we have an asset protection department, it's a little hard to say, that works directly with the police departments to help apprehend these individuals. We have BOLO alerts that go out from our asset protection to all the police in the area, letting them know that this same individual was in Anne Arundel County yesterday. Today they're in Prince George's County, and maybe a couple days from now we show up in Charles County. So that particular business owner, though, they follow the protocol. We work with them. That's part of my job, is to support them in that, and my team's job. But the loss part of it for the items, if it's an ATM machine, of course, that's covered because they don't own that machine, but all of the product in the store that's stolen, all the cash in the store that's stolen, all the cigarettes in the store that's stolen, comes directly out of their pocket. They can attempt to file an insurance claim, but most often than not, it's denied.
You're saying the employee.
The franchisee can often try to file an insurance claim to recoup the monies lost, the amount, but it's often denied.
So is there a minimum amount that y'all would press charges? For example, if I go in there and I steal 2 sodas and it's $10, is that something you would press charges, or it have to be the stealing the ATM machine?
The franchisee would have to make that determination. Often our asset protection will guide them to press charges on larger robberies where we can, have some prosecution.
Thank you.
All right, seeing no further questions, we thank you very much.
Thank you, Mr. Chairman.
That concludes the testimony in favor of House Bill 179. We have one person testifying against, Ms. Hilliard from the Office of the Public Defender. We'll have her come up and get situated, and then we'll ask her to speak for 2 minutes. If I talk a little bit longer, then she can sit down, get a little comfortable, settle in. And Ms. Hilliard.
Thank you, Chairman, members of the committee. Good to see you again. The Office of the Public Defender urges an unfavorable report on House Bill 179. Existing law, there is a theft scheme that already exists. Criminal Law 7103F already allows for multiple thefts to be prosecuted as a scheme or continuing course of conduct. What this bill in practice is likely to do is to infringe on accused individuals' rights to sever charges, provide a defense, and challenge jurisdiction, and cause the additional issue of creating a lower burden of proof, standard of proof, and permit forum shopping by states' attorneys. And I think just very generally, the crux of our concern is that despite an articulated desire to distinguish between those who may steal for need or out of desperation and those who are systemically sort of creating a business or profiting from this, the bill doesn't actually really clearly distinguish those two, and we're concerned about the construction of the bill and the overbreadth of the bill in general, but very particularly, individuals who are shoplifting out of desperation, they, if they were to be subject to prosecution under this, would experience a compounding effect that is, kind of something that we would like to avoid to try and get people out of the criminal cycle. And for those reasons and those written in our written testimony, we would urge an unfavorable report.
Yes, thank you. Ms. Hilliard, I understand your concern, but isn't that what prosecutorial discretion is all about? Because in my 3 years here, I've talked to many state's attorneys, and they decline to bring charges on things all the time. So if it is just a kid who stole a Snickers bar after school, doesn't the prosecutor have the option of not bringing the charges?
That's a great question. Thank you. They have the option, of course, but I have certainly seen in my practice instances where individuals have had charges brought against them in situations that my evaluation would be that they were stealing or committing theft out of need.
Thank you once again, Mr. Chair. Thank you for being here. How we doing? Yeah, so, and we appreciate all the great work that the Office of the Public Defender is doing. Can you give me an example of what is taking place in that space when it comes to how many number of, I asked earlier about an idea of how many numbers of these cases are coming before the courts? And is it resulting in probation before judgment? Or if you're looking at duplication of charges, do you see that these are something that we're not mitigating at the criminal justice level?
And I apologize, I don't have those numbers for you, but I will contact our data people and see if we can get them for you.
Okay, can you give me an idea of, as an attorney, is your office seeing a high number of cases?
Again, honestly, that's something I would have to get data for, just because I don't practice in district court. I always practiced in circuit court, and so I am not fancy, and I also definitely don't want to provide the wrong information, but I will get information as soon as I can. I will say that the district court attorneys who I reached out to about this bill, who unfortunately couldn't testify because they're in court right now, were extremely concerned with the structure and the wording and the overbreadth of the bill.
Yes, if they're district court public defenders, they're unequivocally in court right now. They're probably never not in court. Delegate Conaway.
Mr. Chairman, thank you for coming in to testify. How does one determine what is theft out of need? Is that because your rent is due? Is it because your BG&E is off? Is it because your water bill is off? Or is it because you need a motor for your car? What is that?
I think that's a great question.
It is. You said it.
Yeah.
I'm asking you to define it.
Thank you. I would say that when people's basic human needs aren't being met, if they are committing a theft to meet those basic human needs, that would be described as a need. So I guess I would say food, shelter, and water. But I'm sure that the definition could be expanded or contracted depending on who you were talking to.
Thank you very much.
Thank you.
Why isn't my mic on? I'm going to ask, let's do this again. Delegate Conway has a few bills. We're going to hear House Bill 154 and 164. The bills themselves are not exactly the same. They're a little bit different. But what I'm going to do is I'm going to ask Delegate Conway to talk about the issue in general and then the differences between those two bills. But if you'd like to do each one individually, we can do that. There are two people signed up to testify who are still in the room in opposition on each of those bills. And I'm kind of trying to look at time and make sure that we don't have too much repetition. That's what I'm trying to go with here. So we'll start with House Bill 154. What I'm going to ask when we get to 164 is what's the difference between 154 and 164? And that's what I'll also be doing to those people who are testifying in opposition. And we'll go from there and we'll try and see if this works or if I'm crazy. Delegate Conway, 154.
Thank you, committee. I'm Delegate Conway here to introduce a few bills. This is, most of these bills are a result of assignments for summer study, you could call it. House Bill 1, see my sequence is off. House Bill 154. It's criminal law, fraud, and possession of residential real property. And what this is really dealing with is squatters. And the issue we dealt with last year was it would take you maybe 90 days to get a squatter out of your house. And what this bill does would make a squatter guilty of a misdemeanor if they're convicted. And for their first violation, it would be imprisonment not exceeding 90 days or fine not exceeding $500. Then it escalates from there. So it's very, very simple. What we're trying to do is get a squatter out your house before the 90 days. If you say it's your house, you can prove it's your home. Whether it's your first home, second home, or third home, that person has to get out. And if they were in there illegally, then they're guilty of a crime. They're guilty of a misdemeanor. Their first time out, small misdemeanor, $500. After that, it escalates. That's pretty simple. And we dealt with that last year, and that's why I brought this forward to you. The next bill is House Bill 164. House Bill 164, criminal law, fraud, and possession of residential real property. What this bill does is it requires the sheriff, actually law enforcement, I wanted it to be the police because I didn't want you to have to go and say, get the sheriff to come out and get the person, because then you had to go to court and file. You call the police, there's someone in your house, they're gonna get locked up. That's what we're trying to do, and get your property back to you immediately so that they're not in there 3 months. They know that you're coming. You send some kind of notice to your own house to say whoever's in there is going to be evicted. And then they do what they do. They put concrete in your bathroom toilet and bust out the pipes and all that. And when you come back to your house, you have a shell. So that's what the difference between these two bills are. But they deal with the same issue. Someone has your property. I personally think it's ridiculous that you would have to go to court and wait maybe 3 months to get your own property back. I mean, who's going to pay the gas and electric bill? It's 9 degrees outside right now. Who's going to keep the heat on? With that, I'll be glad to take any questions.
Okay. Are there questions on these two bills, so 154 and 164, from the committee?
Thank you very much, Elwood.
Seeing none, so I'll ask you, and then we'll bring up the two people who are going to testify in opposition to these two bills, Joseph Lovelace and Albert Turner. Ms. Leggett is not online anymore, so we're just going to have the two of you testify. And I'm going to give you some latitude on time, but I think the two bills are relatively similar, so we'll leave it. 3 is fine. That's fine. Go ahead.
Thank you, Chair. Albert Turner, the Public Justice Center, member of Renters United Maryland, in opposition of House Bill 154 and 164. I do want to state, I would speak with Ms. Leggett, who could not make this hearing. She had to go for other personal reasons, but she has submitted written testimony in opposition to both of these bills, which should be in your file as well. I'll keep it very short. Our opposition remains the same as with House Bill 202, which we heard earlier today. Both of these bills raise serious constitutional questions based on the fact that someone can just sign an affidavit, take it to the sheriff's office, and without notice or due process can remove someone out. As we've talked about extensively today, there are many people who are scammed into good faith belief that they are in possession of a property. There are also many times where we're dealing with a individual who actually is in possession of the property correctly, and they need some time to come up with evidence to produce. They need to do some type of evidence collection, and getting a knock on the door by the sheriff's office without no notice or anything of the sort can really, really cause stress and tension on someone who wants to present a defense and cannot do so. In addition, this creates a logjam for the sheriff's office. We believe that this makes a judge and jury, this makes the sheriff the judge and jury and fact finder all in this type of situation, which we find to be constitutionally insufficient. For that reason, we will oppose House Bill 154, 164.
Good afternoon again, members of this committee. My name is Joseph Lovelace. I'm a staff attorney with Maryland Legal Aid, and I too, like with House Bill 202, would voice our opposition to this bill and would ask this panel to give an unfavorable report of these two bills. I spoke a little bit earlier about thinking about perhaps the negative consequences of an enforcement of this bill if things were to go wrong. I'd like to take it a step further. Let's assume for a second that this bill is used to evict somebody erroneously, that they were a lawful tenant, but they weren't able to prove it at time that they were forcibly kicked out by the sheriff's office, but they would have had evidence at a formal hearing that would prove tenancy. They might have had an electronic lease. They couldn't get into their email. They might have not had their phone. These things happen. Well, then that person has a due process rights violation that they could sue the state for, because the state created this mechanism by which, without notice, without hearing, they were forcibly dispossessed of the place that they lawfully owned. So if that were the case, then the state's on the hook for compensatory damages as well as emotional distress. This is essentially what happened in the Fourth Circuit case, Todman versus the mayor and city of Baltimore City with their abandonment ordinance. Here you'd be creating a whole new cause of action, or not even a cause of action, a whole new mechanism by which the sheriff can forcefully dispossess people without any really due process protections. Are the sheriffs suddenly going to be up to snuff on the inner workings of the Maryland rules of evidence? I doubt it. Would they want that responsibility? I also doubt it. So to save the state of Maryland a lot of time and headache, I think we should just kill this bad bill in the bud and not allow it out of this committee. And I'm open for any additional questions if there are any.
Vice Chair first. I see you. Vice Chair, and then Delegates Conaway and Coffin.
Thank you, Mr. Chair. I guess my question is for Mr. Lovelace. I notice on this bill, and I know we're not on the other bill anymore, but I notice on this bill, it says that this does not prohibit an individual for filing basically a wrongful detainer action. Mm-hmm. How could the two work? I was just trying to understand, because this is immediate action, mm-hmm. So would the wrongful detainer action be moot then? Because they've already gotten, I'm just trying to understand how the two could work.
I think it would be moot. If you're given possession by the sheriff immediately, then there would not be any thing to adjudicate in the 14132 wrongful detainer action.
Because the wrongful detainer is sort of like, is the eviction process, right? Do you get money out of a wrongful detainer action?
As my colleague, Mr. Turner, said in his prior testimony in 202, you can, in your complaint for a wrongful detainer, ask for monetary damages. So if you could, show evidence of damage done to the property, you could probably bring that before a judge. Now, the district court, which hears these cases usually, is capped at $30,000. I don't know if that's going to be satisfactory in necessarily all cases. Just spitballing, don't know. But you can.
Okay, so now I understand why the two could coexist. Okay, right. Thank you.
Mr. Chairman, thank you, panel, for coming in to testify. On House Bill 154, page 2, second paragraph, where it says, however, a deputy sheriff may not remove a person who produces evidence of a lawful possession to the law enforcement officer. Doesn't that cover what you just accused this bad bill of not covering?
I don't believe so.
You don't believe so?
No, and the reason why is that the sheriff who is sent there with the express purpose of evicting someone is not necessarily in the right space, nor necessarily equipped to assess whether or not a lease is valid or not.
Yes, then he won't remove the person, right?
You can't say that.
That's what it says in this bill.
That's not what that says in that bill. It's discretionary. And if the sheriff finds in their opinion that what they've been provided is not sufficient, then they may proceed.
So that would be, the sheriff couldn't tell if someone produces something that's considered to be evidence that they should be there? Okay, so if the person belongs in the dwelling, wouldn't they respond to the complaint? If you got a letter to your house that says,
if they were given notice for a court date to be at court to produce evidence, but this bill doesn't envision that. It envisions the sheriff knocking on your door saying, do you have a lease, and are they satisfied by this lease? Because if they're not, then you're out the door.
And if I can add, Delegate, in the state of Maryland, the only thing that creates a landlord-tenant relationship is an exchange of money and someone living on the property. There is no requirement in the state of Maryland that there needs to be a written lease to create a landlord-tenant privity or contract, which means that in a lot of cases, and we see this a lot, a tenant knows someone that they know, there's some text messages exchanged, I'll let you live in your property, okay, I'm paying you this rent, paying you in cash, there's no receipt, right? And so what happens is, if this bill were to be passed, the sheriff could come to your door and say, hey, you need to show me evidence that says that you live here. The person says, well, I have some text messages through this phone. The person who signed the affidavit, he might not be there. There's a whole bunch of other weird factors that could come up from this thing, this idea that to go across this or to push back against this affidavit is just to provide a signed lease that doesn't always come to fruition, because there is sometimes a written lease required for this type of privity and landlord-tenant usage. And so because of that, it's very important that that kind of situation is brought before a judge, and so that judge can adjudicate that type of situation.
Let me spin this a different way. I catch you in my property, and you say that you have a lease. What is my level of recourse? See, I believe in the castle doctrine, so I just want to say that. What is my recourse? I have to go to court for 90 days?
So,
90 days?
So in Baltimore City, I have not seen a wrongful detainer case that takes 90 days. I'm not saying that that's not true. I'm saying that in most wrongful detainer cases that we see, that is not the length of time that we see.
Well, we had previous testimony last year, so.
I understand that, and I'm saying that we don't see that often. We're in court very often. We handle
Okay, you understand it's a statewide bill, right?
I understand that, but in Baltimore City, we don't see that. However, for the purposes of ejecting someone who is in your property wrongful detainer is the correct way to handle that situation.
Thank you very much.
Yes, thank you. And I understand your concerns, but quite frankly, pun intended, I think Delegate Conaway has hit the nail, has raised a very important issue, and it's easy to oppose a bill, but I think Delegate Conway's right to be concerned about this issue. So what's your alternative? And secondly, you're probably going to say wrongful detainer, but if it's such an effective tool, why have we heard so many bills today asking for additional tools?
So if I can, I think, as you said, wrongful detainer is the correct avenue for filing these type of cases. We think that there is a discrepancy between these two portions of the bill, right? So one portion of the bill, I guess all three of these bills, makes it a crime for someone to squat and to also entice someone to fraudulently sign a lease onto the property. And then also it creates a way for someone to eject that person immediately without any type of recourse or due process, right? And so that is kind of the tension that we're focused on here.
Okay.
I think for the purposes of allowing for some type of squatter bill to be passed, at the very least, there needs to be some type of hearing, notice, procedural due process that allows a court to facilitate these type of situations, because it can get a little murky, evidence can get a little strange, and a judge is the most important person to do so. And so under that framework, at the very least, that needs to happen.
Well, okay, just very briefly, Mr. Chair. I think that you raised some valid points, but I also think that Delegate Conway raises some valid points. And so we're early in the session, so I would encourage you to see if you all can collaborate a little bit. Thanks.
If I might answer your earlier question, is what's my alternative? And I'm not sure that getting people out faster necessarily is the right way to tackle this problem. What we have in the state of Maryland is a severe affordable housing crisis where people are being made desperate because the market rents are far beyond what they can afford to pay. We have people paying more than 30% of their income every month on rents they can't afford, getting evicted and having no place else to go. That's going to drive people to do desperate things because they are in desperate circumstances. And so one of the ways, if you wanted to nip this problem at the bud before anybody gets into your house, is to give them a place that's affordable that they can go to. And that would be far more expensive probably than this bill, but it would address the issue holistically by giving people places where they can afford to live. So they're not breaking into homes they can't afford to live in.
And I really appreciate that comment, but I question that comment because not all of the persons that we're dealing with in the squatter situation are doing it because they don't have other places to live. And this is what concerns me. We're suggesting that that's the only reason that this is happening. We've got bad people that sometimes do bad things. But having said that, to Delegate Conway's point, he mentioned the, oh man, I just drew a blank, the doctrine, Casper doctrine. That's scary. But it does say something. I have someone that enters my home. I find out later that they've entered the home. Excuse me. I come back. They're gone. They come back to re-enter my home. I have a right to them protected. This really becomes an awkward situation. My thought is we really do have to fix this. And the question was, what is your recommendation? And I think that's where Delegate Kaufman was getting to. Excuse me. Your thoughts?
So, I mean, I do know that there's been a number of work groups that have been had last summer. I know the Sheriff's Office, Baltimore City, they were in talks with some folks down here in Annapolis on this. To answer your question, I think it is a very complex issue. I think there are a lot of competing interests that need to be balanced here. And to be frank, I can't give you that exact answer on that. we're definitely open to working with you all on this to make sure that everyone is protected in these type of rights and make sure that this doesn't happen. I can tell you that. But I think specifically speaking about these two bills being heard, I don't think that this would handle that situation at all on either side.
And if I might add, I understand that the situation when it's in its worst possible form is quite stark and quite terrible. The reason why we're so concerned about these bills is that it creates a mechanism where it doesn't seem feasible truly for the other side to be heard when the person who filed the affidavit got it wrong. And there are many instances, given the way that the rental market works in this state, where that will arise. So for example, I primarily operate in Hagerstown and Washington County. The property management companies out there don't always put the name of the owner in their lease. So you might have a lease that is from the property management company, and there might be an agreement between the property management company and the owner saying that they're allowed to do that. But what you don't have is a document from the owner of the property saying you are allowed to be there. So if the owner shows up and says, this is my deed, I don't know who these people are, there's not going to be a document that you can pull out in that circumstance that's going to say, this person who is the owner gave me the right to be there. Because of that additional layer of complexity, I think the best way to resolve these types of cases right now is the process that we already have, which is our wrongful detainer statute. If perhaps the state of Maryland wanted to create a form lease of some kind so that all landlords had to have a written lease and then it had to have certain language regarding ownership and that the owner consents to this person residing there, that would assuage at least some of our concerns. But I still think at the end of the day, you're going to need a legal mechanism through a court to satisfy people's due process rights, or else you've got a due process violation every single time, potentially every single time that this statute is used.
So that's actually a point. You mentioned that, the state's attorneys, we don't require a lease or a rental agreement to be in writing. Mm-hmm. And some things we require to be in writing. Would that help?
I think it certainly would. I don't know if it would be, if that's all it would take necessarily to get us, across the finish line on some sort of greater package. In our written testimony by Zephyr Shaw, who's my superior, the director of the Housing Advocacy at Maryland Legal Aid, he pointed out some additional things we would like to see to sort of get to sort of issues in our rental market. I think I have them in a printout of the testimony, but I'll just have it here. We could require that all rental property operators and managers be licensed, that this license be something that we can look up through a centralized database, sort of like our debt collection license. That way, people who are scrolling on Craigslist or Facebook Marketplace can look up and see whether or not this person that they're working with is legitimate, if they're authorized by the state or not. And if they don't see a license there, then it probably means the person's not legit. We would require written leases in all tenancies. State law and several local codes require only owners of 5 units or more to use written leases. So if you're just a mom and pop with 1 or 2, there's no requirement for you to do a written lease. We could create registries within local housing agencies by which renters can register their tenancy information, which the agency can then cross-reference with existing rental licensing information such as owner and operator identity information, and establish a victim assistance fund specific to the relocation needs of residents who face eviction due to leasing scams. Because the number one problem here, and we don't disagree, are these scammers who are creating these fake leases, getting people to give thousands of dollars, because you've got to give a security deposit. You've usually got to pay first month's rent. Sometimes they ask for last month's rent. So you're out of pocket thousands of dollars, all for diddly squat. And there was really no way for you to protect yourself through proper channels. So we would like to see some of those proper channels established before we talk about getting people out of the house any faster than is already done through the wrongful detainer statute.
Delegate Conway, Delegate Embry.
Thank you, Mr. Chairman. So I've had a few situations today where I've heard subject matter being brought up that was not directly referenced, but we all know what it was talking about. So last year, we were faced with a problem where we might have an influx of people coming who can't afford the housing. And you stated that maybe it's because there's a lack of affordable housing and therefore squatting is okay. I guess that's what you're implying. I don't think that it's okay. But my question is, does a homeowner have the right to forcefully remove a squatter on their property if they come to their house, they come home, it's their main dwelling, and there's somebody in their house cooking dinner or cooking breakfast? Can the homeowner, without any potential charges like assault or anything like that, can they remove that person from?
No.
No. Did you say no?
I said no.
Okay, I heard what he said. Thank you very much. I'm on the record.
Delegate Embry.
Thank you. To follow up on properties, I'm sure you know, and that includes owner information has to be entered. Has that helped? Have you seen that make a difference?
He'd have to speak to
Yeah,
that.
so if I can, Delegate. So something that we see often is it does help. The problem is that not all the properties are registered or licensed, right? And we need to make sure that DHCD and their space are making, ensuring that more properties are being registered and licensed, as well as people are aware of how to use the database that is there. I know part of the conversations that we've had with the sheriff is being able to use that kind of database so they can track to see exactly what places are registered, places are licensed, and see if there actually are people there who should be living in there. And I think that for the purposes of that, it also helps because if you see that a property has a violation, right, or you see if they failed something of the sort, a tenant can look that up and say, well, this property has no license, this property has a failed unit, there's no way that they should be renting this unit out, I can't use that. And so those kind of mechanisms are always good to help with that. It's, a lot steps need to be done to implement that, but I believe that is a step in the right direction.
Seeing no further questions, we thank you both very much. That's going to conclude the testimony altogether in House Bills 154 and 164. All right, so now Delegate Conaway has a number of bills, some of which are on the same broad topic. And so what I would like to do, Delegate Conaway, there are 5 bills that are listed as the Porch Piracy Act of 2025, all of which are a little bit different from each other.
Okay.
Do you want to do those as a group? No. Right, so for the rest of the bills that you have, you're the only person who is testifying. So I'm trying to figure out how to.
I would like to go through each one of them. I'll only use a minute each.
All right, that's fine. So we're going to start with House Bill 14. House Bill 14.
Thank you, Mr. Chairman and committee. Frank Conaway here to introduce a group of bills, starting with HB 0014. Is that okay? Yes. All right, thank you, Mr. Chairman. As you know, we dealt with the Porch Piracy Act of 2024, and I was kind of given a summer study, and that was Delegate Toll's bill. Oh, I have permission to use the delegate's name? Yes. Thank you. It was Delegate Toll's bill. And therefore, once I turn this over to the committee, I hope that these subjects will be bundled back into the bill, and therefore we'll all have a chance to put our names on this bill because we all worked on the bills. House Bill 14 is criminal procedure, theft notification of victims and victims' representatives. What you're really talking about here is if someone steals your packages and things of that nature, and they have to go to court, or they appeal their sentence or anything like that, you should be notified. You should be notified of any type of action that's happening in reference to you, because you have some people that they will steal your package or steal from you, and then if they are caught on your doorbell camera or caught on some sort of security system, then they'll retaliate against you. So you really need to know what's going on around you. And that's what this basic part of this bill is all about, that the victims should have a right to know what's going on. I mean, if they catch someone who's stolen your property a year later, you need to know, just in case you might get intimidated at your car coming out the house saying, hey, don't testify against me. So with that, I would answer any questions if I could.
Any questions on House Bill 14? Seeing none, let's go to House Bill 64.
Thank you, Mr. Chairman. Thank you, committee, again. This is theft of mail and packages and victims notification. This bill prohibits the knowing or willful theft of mail or package, which is defined as an item delivered or left to be collected by the United States Postal Service or delivery service company. And what this does is gives a fine for the first, second, and third offenses. And again, we want to bundle all these into one big bill that deals with this package theft. It's a growing problem. We heard about it last year, and we just couldn't basically get it up off the ground. And with that, I'd be glad to answer any questions.
Seeing none, thank you very much. That concludes the testimony on House Bill 64. House Bill 79 now.
Thank you, Mr. Chairman and committee. This is House Bill 79. This is criminal law making a fake, fraudulent, or altered document. We just heard some information about people making fake leases and fake deeds. There needs to be a penalty on your presenting a fake deed or fake lease to anyone, to a lending company, to the police. We need to have some sort of penalty. So this bill makes a violator guilty of a misdemeanor, punishable by imprisonment for up to 1 year and or a fine of up to $1,000. And with that, I'd be glad to answer any of your questions, if I can.
Any questions on 79? Seeing none, thank you very much. We'll go to House Bill 109 now, please.
Well, I don't know about that. But anyway, this is, I know. House Bill 109, criminal law, misdemeanor theft, statute of limitations. You have your doorbell camera, somebody steals your package from off of your door, the law enforcement is trying to investigate it. It takes them over a year, takes them over 2 years to find out who this person is. They get caught on several cameras, but you don't know who it is. Then you find out who it is, so it moves the statute from 2 years to 3 years for the investigation.
So 3 years to 2 years.
Increasing from 2 years to 3 years. That's what, yes.
Questions? We're on 109. 109. Thank you. You're good. All right. Seeing none, that concludes the testimony on House Bill 109. Now, this is the first of 5 bills that are entitled the Porch Piracy Act of 2025, starting with House Bill 126.
Thank you, Mr. Chairman. Thank you, committee. Criminal law, theft, mail, and packages, Porch Piracy Act of 2025. And I'm hoping that I will have some people to join me on this bill. But what this bill basically does is prohibits the theft of mail or packages delivered or left to be collected by the U.S. Postal Service. And if you're found guilty of this, you will have to pay interest upon unpaid restitution in certain cases involving the theft of your mail, and it's up to 5 years. The reason being, you might be stealing checks, credit cards, and expensive insulin and other people's medication to be sold. Now people are getting their medication through the mail, and people know what the boxes look like. I don't necessarily know, but I do know someone who had their insulin stolen, and it was an elderly gentleman. He didn't know what he was going to do about it. So with that, I'd be glad to answer any questions if you have.
All right. With this bill, as I understand it, the difference between this and the other bills is it has a 5-year felony. It requires the payment of restitution. It's a shall. And it requires that the mail be restored to its Honor.
Yes, sir.
That's my shorthand.
Yes, sir.
Delegate Kaufman.
Yeah, just very briefly, Delegate Conway, I'm just trying to understand the scope of the problem. It's still live, the mic is still Okay. I'm trying to understand the scope of the problem. So do you have any data on, like, whether it be in Baltimore City or Montgomery County, like how many packages were stolen off of people's stoops, or where I might be able to find that? I'm just trying to understand. I think I support the bill, but I'm trying to understand how big of an issue porch piracy is. Thanks.
Thank you, Delegate. Respectfully, I'd like to say, I believe you were here last year when this was introduced, and this is me trying to help the state and the committee to come up with one bill where we can solve this problem or do something to help out with this problem. So those figures, I don't have them right in front of me. I didn't think I was going to need them, but if you need me to get them to you, I will.
Okay, thanks. No, just if you could, that's great. No rush, but if you could, that's great. Thank you.
Thank you.
Delegate Grammer.
Thank you, Mr. Chair. Just wanted to make note, I think the idea of mandatory restitution, maybe even for the cost of the package that they stole, like, it's a different way of approaching that, and I think that's a really good part of your bill.
Well, thank you, Delegate.
Thank you.
Further questions on House Bill 126? Seeing none, that concludes the testimony on 126. House Bill 135.
Thank you, Mr. Chairman. Thank you, committee, for your indulgence. Delegate Conaway, Criminal Law Theft Mail Packages Porch Piracy Act of 2025. The good delegate just asked me a question. What this bill does, it requires that the Central Collection Unit be able to retain your information, and therefore, let's say you can't pay for 5 or 10 years. Well, if you ever gone through Central Collection, they'll have it there for you, and if you ever hit the lottery, a person will be able to get their money back with interest. And I'll be glad to answer any questions.
Delegate Taylor.
Who? The criminal gets the money? I mean,
No, the criminal steals your $100 package.
I'm not familiar with Central Repository. I think
No,
that's the
I
issue.
said Central
Collections.
Collection.
I'm
Well,
not
that's good
familiar
that you're
with
not
Central.
familiar.
Yeah, so if you would tell me what that is, maybe that'll help me understand what
Make sure you pay your child support, okay?
Will do. Will do. Thank you.
Oh, that's a sensitive subject.
When generally speaking, you get to the end of the criminal case and they haven't paid something, they haven't paid fees, fines, they haven't sometimes paid restitution, so Central Collections collects it. And as Delegate Conway mentioned, if you win the lottery, if you get a big tax refund, they can take it to pay those things.
Thank you. May I ask another question?
Yes.
Actually, this is regarding an earlier bill, House Bill 79, and just because I know we're piecemealing and we are hoping to put them back together, and I understand that. Does House Bill 79, is that also a porch piracy related bill? It talks about mail fraud. So is that different in content?
No. That's dealing with making fake, fraudulent, or altered documents like the fake lease.
I understand that. That will not be considered when we're looking at potentially creating the final.
The porch pirate? No.
Okay. Thank you.
Thank you, Mr. Chair, and thank you, my friend. No, I was going to also say that if you got a tax return, anything, they will, paycheck, whatever you get from the state, they will. That's that's like the state's collection agency. So Mr. Chair answered it, which I think is a wonderful part of the bill to be able to, individuals obviously don't have a way. Look, if you've taken somebody's stuff in $5,000, $10,000, that's, or $250, you may not have a way to pay that back right away. So having the state being able to recoup that, I think that's a fantastic way, Delegate Conaway, to make individuals whole as much as you can. So I'll let you carry on, but I just want to give you a little bit of flowers right now.
Thank you very much.
Thank you, Mr. Chair.
Further questions? All right, seeing none, that concludes the testimony on House Bill 35. We're at House Bill 143. Go ahead, Delegate Conaway.
Okay, House Bill thank you, Mr. Chairman, thank you, committee. House Bill 143, Criminal Law, Theft, Mail, Packages, Porch Piracy Act 2025. Basically, what this bill does, it says if you were convicted of stealing a package from someone's porch, you would basically have what would be called like a property ex parte, where you can't be on that person's property. Hey, you snooping around looking to see what kind of boxes they are. You can get another charge, and you could be guilty of a felony and subject to imprisonment up to 5 years. And I'll be glad to answer any question.
Questions?
Thank you. Thanks for bringing the bill. Can't you already get a peace order against somebody if they've stolen off your property?
Do you know who it is?
What's that?
Do you know who it is?
Well, you're not going to be able to charge them with a crime if you
until you find out who it is, and then once you do, you get the stay away.
Well,
peace order. Okay.
So, well, can you? I'm asking you. Can you get a peace order against somebody?
I believe you can.
I think. Wouldn't you have to? Usually, a judge would ask what threatening behavior
that you
have they committed against you, wouldn't they?
I'm here to make the law. I'm here to make the law. So whether you can do it or you can't do it, in the whole package of bills, I want to say that that's one of your rights.
Right.
That you will have.
Here, I'm just pointing it out that it may be a better way to go to amend the peace order statute to allow you to get a peace order against them. Then if they violate that, then you can go after them for other sanctions like some sort of criminal activity for violating the peace order.
I thought about that, but I don't necessarily want to make the peace, I didn't think that I would want to make the peace order a separate action, because someone already stealing from your property, they're not in the frame of mind that they understand what a peace order is and what they can and cannot do, because they should already know that they shouldn't be stealing off your porch.
Okay. Thanks, Mr. Chair.
Delegate Sue? Oh, I'm sorry, did you?
I was saying, I was going to address that.
Delegate Cole, then Simpson.
Oh, thank you. I was just going to say, yes, I agree with Conaway. Yes, you know, having someone stay away from your property if they've done this before, because we see repeat offenders. Is that so? Is that the case?
That is so.
Is that so? Okay. Did you see repeat offenders come back and do it several times? So you want a way to be able to really make it clear that there's, further sanctions if you were to repeat that offense again?
Yes, up to 5 years.
Okay, thank you.
Delegate Simpson?
Am I understanding correctly that what this does is it's an automatic, peace order as opposed to what he's talking about that, obviously they know who it is in order to do this, but you're making it, which I think is really cool, because I think we could have it in other areas where it's just automatic. You did this, you shouldn't be on my property, as opposed to then I have to take that additional step of getting a peace order. This bill would make that automatic.
Yes, that's correct, Delegate.
All right, seeing no further questions, that completes the testimony on House Bill 143. Now, there are two other bills that are not in numerical order that are also Porch Piracy Act of 2025. One of them is House Bill 210, the other is House Bill 280. Can we do House Bill 210 so I can kind of keep these together a little bit? House Bill 210?
Yes, sir.
Go ahead.
Thank you very much, Mr. Chairman and members of the committee. I'm Delegate Conaway here to introduce House Bill 210, Criminal Law, Theft, Mail Packages, Porch Piracy Act of 2025. I'll simply tell you what's different about this bill. For the third or subsequent violation after the third, the court may order a defendant to participate in a diversion program in lieu of incarceration. In other words, so they might be stealing your package because they have a dependency and they need to go to a diversion program and need help. So if they don't want to get help, let them go to jail. And I'll be glad to answer any questions.
Questions? All right, that's fine. That concludes the testimony on House Bill 210. Now House Bill 280.
280, well, it's kind of out of order in my opinion, but House Bill 280, Criminal Law Theft Mail Package Porch Piracy Act 2025. Again, this is part of a whole bill concept. And for the third or subsequent offenses, the person that would be found guilty of stealing your packages would be required to participate in a substance use disorder evaluation and treatment. And with that, in lieu of incarceration. And with that, I would gladly take any questions.
Questions? Okay, so that was House Bill 280. That leaves three more, starting with House Bill 177.
Oh, okay. Thank you, Mr. Chairman. Thank you, members of the committee. House Bill 177, Criminal Law Theft and Opening of Mail Packages. This is requiring the court to notify the United States Postmaster General of a certain conviction involving the theft, taking, or opening of mail packages under certain circumstances. So you might have someone that's scanning your mail and they're looking for checks or credit cards, and so something comes through as a coupon, they leave that, but then they find your income tax return check and take that. Well, if they're found guilty, it should be reported to the United States Postmaster General, and that's what I'm asking. And I'd be glad to answer any questions.
Seeing none, that concludes the testimony on House Bill 177. We're now at House Bill 269.
House Bill 269, Criminal Law Petty Theft, Statute of Limitations, increasing from 2 years to 3 years the statute of limitations applicable to a crime of theft of property or services with a value of less than $100. You keep catching this nuisance person stealing your packages, but you just getting little things, perfume, well, not to say some of you wear perfume more expensive than $100, but anyway. You have things that are less than $100 and they keep stealing things from your porch and you catch them on your doorbell camera. Well, we want to increase the penalty from 2 years to 3 years that they can be charged. And that's on $100 or less. Because it might take time for you actually to find out who these people are if they're in rotation. So I'll be glad to answer any questions.
Questions? Seeing none. We now are going to House Bill 290. Oh, that concludes the testimony on House Bill 269. We're going to House Bill 291. Go ahead.
House Bill 291. This bill increases the fine for taking and breaking open a letter, as we talked about before. This bill increases the fine from $15 to $500 as a maximum fine. And that's all this bill does, increase the penalty.
So it would go from 6 days and $5 to 6 days and $500, I think?
Yes.
Okay. Delegate Williams.
Thank you, Mr. Chair. Delegate Conway, I guess I'm just trying to reconcile, what's the difference between 177, House Bill 177 and House Bill 291?
The letter breaks open.
Oh, okay.
You're not stealing the package, the letter, you are opening a letter, I think is the distinction.
Yes.
Got it. So this is just opening?
Yes.
177 is just opening versus
Yes.
291 is the taking?
Yes.
Okay. The taking and the opening. Okay, thank you.
Thank you.
Any further questions? Seeing none, that concludes the testimony on House Bill 291 and completes the bill hearings for us here today in the House Judiciary Committee.
Thank you, Mr. Chair.
Thank you, Delegate Conaway. And that's fine. We are done for today. We have bill hearings tomorrow and on Thursday, and we'll have more information for everybody about future weeks here very shortly. Thank you all very much.